suit that your lordship has almost, my lord, concluded hearing. My lord, may we only request, my lord, fixing of a date this side of the vacation so that we can only file the written notes and, my lord, conclude.
Only written notes?
Yes. Cost. Affidavit of cost and written notes, my lord, that is all.
Oh, yeah. Hey. 25th or 12th? 11. 12:30 है 11:30.
25th. Grateful.
May my lords leave to mention another insurance matter,
Yes.
but nothing to do with the suit. It is kept for tomorrow at 2 p.m. By application, I'm not enjoying any interim order. This is for disclosure of documents. Tomorrow, 2 p.m., this is a matter fixed. Immediately after reopening any day.
Okay. Note kar lo. It will be in the list. Mention anybody. You in what is the
This is tomorrow 2 p.m. This is
hearing?
Yes, for hearing.
You inform the others.
I have informed. I have given notice to others. I'm good.
With your lordship's kind leave, my lord, this pertains to, my lord, that election petition which was attempted to be mentioned on Friday, my lord, by one of the parties, my lord, who is a stranger, my lord, to the proceedings. So, my lord, upon being refused, my lord, in the evening, my lord, there was a lengthy mail which was my lord, received by my learned advocate on record. Peculiarly, my lord, they demanded for a copy of the entire cause title, for a copy of the other election petition and the gazette notification. But, my lord, upon appreciation of the fact, my lord, that the law does not provide, my lord, for such a provision, my lord, and admittedly they do not have the gazette, but they have the knowledge that they. So, my lord, we have, my lord, not replied to it, my lord. So, possibly, my lord, today also they will again try, my lord. My lord, it was my duty to inform your lordship, my lord. So, I'm informing. I'm grateful to your lordship.
GA2 of 2024 is dismissed.
The GA1 may be fixed for hearing on any demolo. GA1 is kind
Mention after vacation.
Item number.
Madam.
Yes.
Just for extension, my lord, for the time. My lord, my learned friend is appearing virtually.
I'm appearing for the defendant, your lordship, my lord.
Cross-examination, my lord, of the defendant's witness is going on, lordship. We've had two.
You are appearing for?
No, I'm for the plaintiff, lordship.
Plaintiff witness is over?
Yes, my lord.
Cross-examination going
of the defendant's witness is going on, my lord. It's on commission.
Cross-examination of the defendant witness?
Yes, my lord. Cross-examination. They have filed their affidavit of evidence, my lord, 1 month ago. And my lord, in all fairness, my lord, he's quite ailing. So, my lord, I will not.
Cross-examination not yet started?
My lord, it has started. We have already had 2 sittings. Yes. They tendered their evidence in chief and cross-examination has also started. Lord, we're praying for, my lord, if the time can be extended up to December, lordship, because, my lord, this month also we will not have.
It is informed by the learned counsel for the parties that cross-examination of the defendant witness is going on commission and prays for extension of time to file report by the commissioner. In view of the submission made by the counsel for the parties, time to file report by the commissioner is extended till 17th January 2025 or on the matter.
My lord, if I may, my lord, humbly beseech your lordship. My lord, the witness might not be available for the entire November month, my lord, due to his health checkup. Lordship may kindly extend it 1 week also. I mean, lordship, at least end of December.
End of 24th is the last date. 24th, you all person will not work. Okay, 23rd. 23rd.
Lordship, grateful to your lordship.
23rd December has to be mentioned for filing report.
Grateful, lordship.
Item number 3.
Today was the date for filing of the notes. May I file my notes below? Well, the copies are coming. I'll give to my learned friends. Amar asked you. They are not here, I think.
My lord, the notes for all the different.
I have filed the notes, my lord. Only a point which they have raised in their
Acha,
notes,
yes.
but they have not, my lord, argued. I have also included in my notes, my lord. That is on some documents. my lord.
নোটের কপি তো দিলাম না কি করে জানলে কি
না 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 তিলকদার নোট
ও আচ্ছা
তিলকদা তো নোটটা দিয়েছে আমার
হ্যাঁ ওটা জিএ টু
Filed all,
my lord
all file
filed.
all the defendants
all filed.
all file
Parties have filed data notes of argument. Fix for orders.
wait Lordship may have to carry this to Andhra. Lordship may have to carry.
we have bought you, my lord with some work
Before
to the vacation
I will dispose of him.
Wait.
This one, other will carry.
My lord, I appear for the degree holder, my lord. Here, my lord, there was an issue whether, my lord, the lady Malovika Sengupta, who is a director of the judgment debtor, whether she can be produced in court, because lordship pursuant to my lord's order of 8th of September 2025 directed issuance of warrant of arrest.
8th of September.
Yes, 8th of September 2025. Paragraph 4, page 2 of the order.
Yes.
Yes, my lord, the difficulty that we are facing is, my lord, the sheriff, my lord, has indicated to your lordship, my lord, that the lady cannot be arrested
Yes.
pursuant to the order of 8th of September. But,
Yes.
my lord, we have found out, my lord, the particulars from the MCA portal, where we have given a copy that that this lady is the, my lord, whole-time director of the company, and she is the person in control of the judgment debtor. Because, my lord, only one thing, your lordship, it kindly takes the execution application, but the decree is annexed. Something very important. My lord, the decree starts from page 30 of the execution application.
Yes.
Yes, lordship will kindly take, my lord, page 44, which is internal page 15 of the decree, paragraph 15.
Yes.
Yes, kindly see, my lord. The defendant had also examined one witness, namely Mrs. Malovika Sengupta, CEO of the company, but the cross-examination of the defendant number 1 was deferred on 17 December 2019. Since thereafter, the defendant has not produced the defendant witness number 1 for further cross-examination, in spite of several notices issued by the counsel for the plaintiff to the defendant, and accordingly by an order of 3rd of May 2023, the evidence of the defendant was closed. It is found from the record that since 6th April 2022, none appears on behalf of the defendant. During the argument of the matter, this court found that the matter is connected with commercial dispute, and by an order dated such and such, this court had transferred the matter to this court. After transfer of the case, the plaintiff had also issued notice to the advocate on record of the defendant, but in spite of receipt of the notice, none appears on behalf of the defendant. Now, this is the first finding, that it is a deliberate attempt to avoid the service. Now, lordship will kindly take, my lord, internal page 26, my lord, running page 55 of my application, paragraph 21 of the decree.
Yes.
Yes, the defendant has also made their counterclaim, but the defendant has not proved the counterclaim and the defense set out by the defendant in the written statement. The defendant has cross-examined the plaintiff's witness, but the defendant failed to bring his witness, that is DW1, to complete the examination. Counsel for the plaintiff has partly cross-examined the DW1, but subsequently the defendant number 1 has not produced the said witness to complete cross-examination of the DW1. None on behalf of the defendant has argued the matter also. During the evidence stage, they stopped appearing. But this is a deliberate attempt to avoid execution of the decree. Because since at the time of the trial, if the defendant disappears,
Yes.
then they know that they do not have any defense. Decree will be passed as a matter of course. And Lordship has recorded in my Lord's order of 8th of September 2025. Then even after service of notices, they are not appearing.
First time they accepted it. Second time they have.
Because in the first service was delivered on them. The subsequent services could not be delivered because your Lordship records that the postal department's consignment has come back with the endorsement no such firm. 8th of September, my Lord's order, paragraph 2.
Yes.
But this is something very, this is just to avoid the execution of the decree. I have a decree of approximately 1.86 crores. I am not in a position to bring the judgment debtor in court. There is no, they are unrepresented, no affidavit of assets has been filed. If this is the situation, the decree that your Lordship has passed, it will be an infructuous. The sheriff, has indicated because of section 56, perhaps, of the Code of Civil Procedure, I will not be, the warrant of arrest cannot be executed against the lady whole time director.
Yes.
Yes, but there is one provision, as I had order 21 or rule 41 sub rule 3. Perhaps this provision might have an effect of diluting the strictness contained in section 56 of the Code of Civil Procedure. Kindly see order 21, rule 41 sub rule 3. Yes, it's kindly see rule 41 is regarding examination of judgment debtor as to his company. Rule 2 provides for filing of affidavit of assets, where if it's a case of a corporation.
Order 21.
Order
rule?
21, rule 41,
Yes.
examination of judgment debtor as to his property.
Correct.
Rule 2 of order 41 provides that kindly see where a decree for payment of money has remained unsatisfied for a period of 30 days, the court may, on the application of the decree holder and without prejudice to its power under sub rule 1, by order require the judgment debtor, or where the judgment debtor is a corporation, any officer thereof to make an affidavit stating the particulars of the assets of the judgment debtor.
Yes.
So an officer of the corporation may be directed to file an affidavit of assets.
Correct.
Now kindly see rule 3. In case of disobedience of any order made under sub rule 2, the court making the order or any court to which the proceeding is transferred may direct the person obeying the order be detained in the civil prison for a term not exceeding 3 months unless before the expiry of such terms the court directs his release.
Correct.
But this provides, rule 3 provides that if there is any violation of any order, then appropriate orders can be passed. But I have looked out, I've searched also, there is no definition of the word person in the Code of Civil Procedure.
Correct.
The definition of the word person is there in the General Clauses Act section 3 subsection 42, which also includes a company. And here the judgment debtor is the company.
She's the principal officer.
And she is the person who is actually in control of the management. And she is the whole time director. And that is the reason why she was brought into the box to lead evidence on behalf of the defendant.
The decree against the judgment debtor, that would have applied. Versus Malobika, then it would.
Perhaps the strictness of section 56, in my humble submission, perhaps will not apply. Because here, the decree is not against the lady director. Kindly see, section 56, notwithstanding anything in this part, the court shall not order the arrest or detention in the civil prison of a woman in the execution of a decree for the payment of money.
Correct.
So perhaps in my humble submission, section 56 proceeds on the premise that the decree is against the woman.
No. Again, not the against whom the warrant will be issued. If she is only the CEO.
Yes.
And you also harping upon that, yes, she is the CEO.
Yes.
So against whom the warrant will be issued?
Because my lord,
officer of the company.
yes,
For you to bring on record, yes, other than this, they are the other persons.
my lord, the other directors, my lord, let warrant of arrest be issued against the other directors then.
Correct.
I
You
mean,
have to make an application on that.
very well, I'll make an application in the,
You have two options.
yes.
Either you find out the property and file an application for appointment of the receiver so that the property can be attached. Or the second, if the other officers are there other than the lady, you can make an application for attachment.
But in the execution application, my lord, there are certain prayers if lordship sees, my lord. I have also prayed for a, my lord, appointment of a receiver, my lord, take possession of the assets.
Correct. Where is assets? What are the assets?
My lord,
Where
that
is the
my lord, we,
schedule?
then my lord, I'll come back with an appropriate application.
You come with the appropriate application with the
But in the,
schedule of the properties,
yes,
either bank or whatever, the movable or immovable. Second, if other than the she is telling that she is CEO, and if
yes.
the master data is other persons are there, if they are the officers of the company, you can make an alternative prayer.
Then my lord,
for-
only kindly, my lord, then kindly issue a subpoena on the other directors.
That's why first you have to bring.
Very well, I'll না অন্যরা application করতে হবে
You have to bring on record. You have to bring on record.
তিনজনের কাছে I'm told my lord, the warrant of arrest has already been issued against the, and it has been lodged with the department.
No, that's why they are the department is of the in dilemma. That is the lady.
Well, lordship will kindly stay the execution of the warrant of arrest against Mrs. Sengupta. But so far as the others are
Where are
concerned,
the others?
my lord, we have lodged it. But there are other directors. Yeah, sure. এটা কার against এ? Yes, my lord, one of the director is Mohammad Fayaz. But this is the first warrant against Mohammad Fayaz, who is also a director, and these are the others. ওই master data বার করো। Yes, my lord. I have also given the particulars of the directors of the judgment debtor at para 38 of my application.
Rasul Ahmed, Mohammed.
Yes, Rasul Ahmed, Mohammad Fayaz. My lord, there is one Mr. Adesh Kumar Gupta and my lord Malavika Sengupta.
Adesh Kumar Gupta. These are the three.
Yes,
And other than the
yeah, Malavika Sengupta.
So how you conduct this? These three are the directors.
My lord, we have the master data.
In the master data
Yes,
is
yes.
reflecting.
Yes. Well, I'll hand over a copy.
ये रिपोर्ट क्या है मास्टर का ये सॉरी
Yes, my lord.
ये
ये দুটোই দিয়ে দাও।
क्या रिपोर्ट देखो पढ़ो
লাল
आपको
টিক
समझ
মার্ক
में
করা
आता
আছে।
नहीं
আর and my lord, this is another MCA portal.
बोलते उन्हें
এটা ওটাই। আরেকটাতে রেড টিক মার্ক করা আছে।
क्या लिखा रिकॉर्ड एंड नोट
মানবিকের ক্ষেত্রে সাকিনা
by an order dated 8 September 2025 this court has passed an order for issuance of warrants against the judgment debtor. In compliance of the order dated 8 September 2025, the decree holder has filed the requisites in the department for issuance of warrant against Malavika Sengupta.
Yes, Malavika is here.
Against Malavika Sengupta, who is the whole-time director of the judgment debtor company, as well as the other directors, namely Mr. Adesh Kumar Gupta, Mr. Rasul Ahmed AHMAD, RASOOL, Rasul Ahmed, and Mr. Mohammed Piaz, P-A-I-Y-A-Z. Paya. Full stop. The department has placed the matter before this court by referring section 56 of the CPC and submit that one of the director, namely Maulabika Sengupta, is a lady, and as such, no warrant can be issued. Lady matter woman, and as such, no warrant can be issued against the woman, as the present execution proceeding is in connection with the money payment. At the full stop. Produce the report and the requisites filed by the plaintiff, filed by the decree holder for issuance of the warrant, as well as the this court find that section 56 of the CPC provides that, inward comma, notwithstanding anything in this part, comma, the court shall not order the arrest or detention in the civil prison of a woman in execution of a decree for the payment of money. Inward comma. Considering this provision, the department is directed to lay hands and not to issue warrant against Srimati Maulabika Sengupta, who is the full-time director of the judgment debtor company, but that department is directed to issue warrant against the other three directors.
Yes. But it was already
I issue. You submitted, na?
Yes. But we have to go and lodge once again.
No. Issued warrant against the other three directors, against which the decree holder already submitted the requisites in the department.
Right.
Returnable. Before vacation, it is not for.
No, kindly keeps it after vacation, but only one indulgence. So far as Maulabika Sengupta is concerned, may a subpoena be issued from this honorable court and appropriate notice be served through the concerned police station within whose territorial jurisdiction she resides.
Returnable on 4th of November 2025. As no warrant can be issued against the woman in terms of section 56 of the Code of Civil Procedure, accordingly, the petitioner, the decree holder is directed to take appropriate steps for issuance of subpoena upon Malika Sengupta through the concerned police station. Who is the police station?
But this is Okhla Industrial Area Police Station, New Delhi.
That is Okhla Industrial Police Station, New Delhi, and the police and the in charge of the said police station is directed to serve the subpoena upon the judgment debtor and to file the report on the returnable.
Great. Or we'll write it down in a piece of paper and give it the. It's okay.
Area police station.
You give.
Grateful. Manoj.
Extremely great.
Yes.
Lord, I'm appearing on behalf of the plaintiff. It is a unfortunate case. My husband was a
Already 6 dated figure 6, Mr. It is 6th number kar do. Yes.
My lord, this is an unfortunate suit. I am the wife of a deceased partner, my lord. My husband was the partner of the partnership firm since 2007. He was the working partner receiving salary, interest on capital, but he unfortunately expired in the year 2017. Now, prior to that, this partnership firm was founded by my great father-in-law, along with my father-in-law and his two brothers. That means there were 4 partners. And while these 4 partners were doing the business, from the profit of the business, they had purchased a immovable property at Howrah, which the ground floor was used for the purpose of go down, and the upper floors was used.
Hello.
was used for matrimonial renting purpose. And our partnership firm, it was
Many partners were there in the partnership.
originally there were 4. In due course, all the founder partners have expired except my uncle-in-law. He is still alive. And in their place,
Other than there are no other partners.
no, as and when the original
Today, how
partner,
many partners are there in the partnership?
at the time of the death of my husband,
Yes.
there were 3 partners. One is my husband, who is the son of one of the original partner, founder partner. Then another, my cousin, brother-in-law, who is also a son of another partner. And the original partner, 3 of them, my lord.
So now
And at present, my lord, the situation is
the
totally
death of the husband of the plaintiff.
totally different, because they have
No, that's why after the death of the husband
only
of the
two,
plaintiff,
only 2 were
two
carrying on.
are there.
2 were carrying on, my lord.
There is no further induction of the partnership.
No further induction of partners, even though we wanted to be a partner, but their only ground was a housewife cannot be a partner. A daughter can be a partner, but a housewife cannot be a partner.
What is the age of the daughter? What is the age of
No,
the daughter?
the daughter's age is 12 years, but their
12
logic
years.
12, 13 years. But their logic is the daughter of the family can be a partner. But a housewife of the family cannot be the partner. This was their logic. Because later on, we will find that one of the Karta's daughter became a partner. But they never allowed the housewife to be a partner for reasons best known to them. But initially, after the death of the husband, they were paying 24,000 rupees till 31st March 2024. As interest on capital or whatever to assist the deceased partner's wife.
What they have calculated? What is the amount paid to you? That is a share.
Fixed amount of 24,000 per month. Because the deceased partner was receiving a partner's remuneration, interest on capital, share of profit. They said that you take this amount, we will in due course, we will settle it. But all of a sudden on 31st March 2024.
Have they made any proposal for payment of one-time settlement?
They had made a verbal proposal of 45 lakhs rupees, which is not at all the true value which a deceased partner's share should come. Because it is a partnership firm of more than 100 years.
Okay. So what is your prayer here now?
My lord, there is certain incidents have happened which I should mention. Number one is, when they stopped the payment, I had made certain investigation and have found the house property at Howrah has been totally sold off. Even though my father-in-law is...
When he died?
In 2017.
So what you are doing for the last 5 years?
Since at the earliest opportunity, the negotiations, the letter correspondence have started, and the first letter was given by them itself on 21st November 2017, within a month or so.
Correct. You made representation.
Yes, my lord, at page number 273 to 276.
Correct. Now, first you have given the December 2017.
Yes, my lord, we gave a reply. We gave a reply on 9th January 2018 that I want to be a partner.
Correct.
So,
what has happened after
that? They kept on paying the 24,000 per month, admitting me that I have certain locus standi. All of a sudden, from 1st of April, they stop everything.
1st of April of
2024. And I find that the entire house property of the partnership firm has been sold without my signature. My father-in-law has signed in that particular purchase deed. But when it is sold off, I being the legal heir of the father-in-law, through my husband, my signature, my daughter's signature, who's a minor, no application has been made before the district judge for the sale of a property where minus interest is involved.
So why it is a commercial?
My lord, since I'm a partner, my husband was a partner, and I want to be a partner. So it comes under the purview of the Commercial Courts Act. And my lord, another important point is this partnership firm, they are making the turnover into zero. They have formed another partnership firm whose partners are the wife of these continuing partners, wife and daughter. And the turnover is coming to zero, and this turnover is rising and having a tax audit or whatever it is required. Number one. Number two, the tenancy, which was in the name of the partnership firm for the past so many years, since 1924. Now the tenancy has come in the name of the new partnership firm. Only one alphabet has come before. Here it is Bengal Supply Agency, and the new number is Bengal Supply.
What is the business?
It is supply of chain iron chain, which are mostly used in the marine purpose, in the ships. They are the very old supplier of this type of items, and having a tax audit since a long time. That means the turnover is very good. And all these documents which we have filed today, we have obtained it only through RTI Act. We are really thankful to the Act. The Income Tax Department has provided us the income tax returns for the past several years, which will prove that my husband was getting a partner's remuneration. And the turnover will be proved by those papers. From the bank, we have come to know that the old bank accounts have been totally closed. My lord, we have mentioned it in our in the description portion that
Now, what you want?
I have given in the prayer portion, my lord, that induct me as a partner. This is my primary prayer. And
No, the prayer is the cancellation of the deed.
Yes.
Cancellation of the sale deed.
Yes, my
Second is
lord.
the decree of eviction.
Yes, my lord.
That's why I'm asking.
The prayer. Yes, my lord. Because
decree for declaration pending absolute legal owner of the possessor. Then decree impugn sale deed. Where is your for inducting you a partner?
Yes, my lord. It is given in the subsequent prayers, my lord. Kindly give me a moment. The property which has been sold belongs to the partnership firm. Partner. My lord, prayer number I. Induct the plaintiff number 1 as a working partner of the defendant number 1 partnership firm in place of deceased partner.
Why of clause 12? Why you have prayed for clause 12? You approach the pre-mediation process?
Yes, my lord. Yes,
what
my
has
lord.
happened? They appeared?
Yes, my lord. The non-starter report has been generated.
They appeared, not appeared?
They did not appear. And my lord.
So why clause 12?
Yes, my lord. 1 minute. My lord, this is the order passed by your lordship on 8th May 2025.
Why clause 12? You are outside. All are outside. Why do you have filed the suit here?
No, my lord, my partnership firm is within the jurisdiction, my lord. I have given.
Place? Which place?
It is.
Where is the place of business?
Raja Woodman Street, which is within the original site jurisdiction.
Where you mention?
Yes, my lord. We have mentioned it. My lord, if you allow me to read that portion, that paragraph 2. My lord, the defendant number 1 is a partnership firm named Messrs. Bengal Supply Agency, also known as Bengal Supply Agency, whose original founding partners were Balai Chandra Mujumdar, son of late Nagendranath Mujumdar, since deceased Dilip Kumar Mujumdar, son of late Balai Chand Mujumdar, Deepak Kumar Mujumdar, son of late Balai Chand Mujumdar, since deceased, and father-in-law of the plaintiff number 1 and grandfather of the plaintiff number 2, and Devaki Kumar Mujumdar, son of late Balai Chand, having its office and place of business at a tenanted premises situated at 22 Raja Woodman Street, Room B, Post Office, Khangrapotti, Police Station, application Barabazar, Kolkata 7
Praying
lakh
for,
1 within the original jurisdiction.
praying for declaration of the sale deed dated 25th of January 2024. 2024 as null and void, and and other prayers. Good. Counsel for the plaintiff submitted part cause of action arose within the jurisdiction of this court and past cause of action arose outside jurisdiction of this court. The plaintiff has specifically averred that the partnership firm is within the jurisdiction of this court, and as such, the plaintiff prayed for leave under clause 12 of the latest patent. Why order to rule 2? Latest patent. Considering the submission made by the counsel for the plaintiff, leave under clause 12 of the latest patent 1865 is granted. Counsel for the plaintiff submitted, though the plaintiff has filed the suit praying for several relief, but there is a chance that further damage may occur, and the plaintiff may pray for the further damage in future, and as such, further compensation in future, and as such, he prays for leave under order to rule 2 of the CPC. Consider the submission made by the counsel for the plaintiff, leave under order to rule 2 of the CPC is granted. Plaintiff is admitted, subject to scrutiny by the department. Next.
Much obliged.
Number 6.
First, the 12A leave.
Yes, why 12A, sir?
Well, this is an interesting suit.
Interesting suit.
Right.
Every suit.
This is basically a artificial intelligence suit. Well, the entire thing is based on an agreement by which we are a company. The plaintiff is a company. What we do is that we specialize in artificial intelligence and we give service support to make companies grow through artificial intelligence. The defendant is a company which is engaged in the business of digitization of land records of the state of West Bengal. As your lordship is know, like we have digitization of the Calcutta High Court records. So all old records are being digitized. So this is the process. So they were doing it in a manual way. So we said that we are expert in the world. We do artificial intelligence. So we got into an agreement. Now, so far as the 12A, let me satisfy your lordship was on 12. Now what has happened is this agreement, under this agreement, the shareholders is a closely held company of the defendants. Now he said that he will induct me and my nominees as shareholders in the company, and I will eventually get 75% of the shareholding in the company. I will bring in by way of share application money, which is basically, that is how the company generate funds through rights issue. That I will bring in 3 crores. And he will give me 75% stake in the company, and I will be the director and my persons will be the director. There will be 3 directors from my side on the company. And this is a non-determinable contract. I come in, I bring in about 49 lakhs initially, though I was not required to. He has to first initiate the process of rights issue. He did nothing. Then, my lord, what we did is we procured through our expertise resources from all across the world. My lord, your lordship will find from the documents, there's a company by the name of DAG, which was involved, and they started the process of digitization. Over the last 1.5 years, the company's the revenue and so far as the company's output has increased at least by 5 times. I have brought in the entire, now he has got access to the digitization technology through DAG, through the people I have recruited across the world, people from doctorates in geotechnology we have included, all mine. Now he is know the business. Now he wants to throw me out. So what he does, first thing, he issues me a termination notice. In a non-determinable contract, he issues me a termination notice. I respond. So now what he's done is that he's changing everything, and my lord, this is what the situation is. Now basically what he'll do is that he's taken my technology, my everything. Now he wants to get into, that is our apprehension, with a third party, and because the value and worth of the company has increased multiple times. So my lord, this is the situation. Now he's trying to throw me out in a non-determinable contract by terminating. My lord, this is the reason, my lord. Now unless we get immediate interim protection, so my lord, he'll basically change the entire structure of the company. So I'll be nowhere anyway. My lord, if your lordship takes the plaint, para 39, page 16 of the plaint, your lordship will find the pleadings.
When it was terminated?
Well, 11th of June. 2025. Immediately we responded. Thereafter, notices were exchanged. But this is interesting. I'll come to the termination notice and the subsequent exchanges. But for the purpose of my lord, 12A, my lord, my pleadings is 39. And my lord, I also rely upon your lordship's judgment in the case of Tirupati Vancom, which follows Srishti, division made Srishti. And my lord, your lordship is aware of Dhanbad fuels. Dorkan nahi.
Yes. When the agreement was entered between?
My lord, the agreement is dated 26th of August 2024.
And terminated on?
My lord, terminated by the notice 11th of June 2025.
Where is the termination notice?
My lord, if your lordship takes the interlocutory application, it's at page 195. And the suit, if your lordship takes the suit, we've disclosed the documents in the suit as well.
Page?
It would also be at page. In the plaint. Also at 195. Interlocutory application, plaint, same page, 195. This is the termination notice. And my lord, the grounds that he has given, each of the ground is contrary to the agreement itself. So if the termination, as your lordship is well aware, is settled for the hundreds of years, if the termination is not in terms of the contract, that termination is void ab initio. And my lord, interestingly, this contract does not provide or does not give any authority to any of the parties to terminate. That in case of breach, you terminate, nothing. In the termination notice, he says that you've not done this, you've not done that. That is exactly what I was not supposed to do in the contract.
Quick advisory, you are. Plaintiff is the quick advisory.
Yes, my lord. I am quick. I am Q. ASPL is the plaintiff. My lord, kindly take the third paragraph. What does he say?
What are the amount you have paid?
Correct. My lord, kindly see the first paragraph. It was also agreed that QASPL will arrange to pay a sum of rupees 3 crore to SN upfront against 75% of the shares being divested. My lord, just pause here for a moment. My lord, kindly now take the agreement, which is, my lord, at page 30. And my lord, kindly take, it starts at page 30. My lord, kindly take page 32. My lord, Roman 8. My lord, the whole issue is, well, if it is recorded here, if your lordship will take first Roman, I'll just give your lordship. Kindly take first paragraph 1, Roman 1. QASPL will infuse a capital. Is your lordship found it? Page 32, 31. 31, I stand corrected, my lord.
Yes.
31, your lordship will see it says, it has been agreed that QSPL will acquire a controlling stake in Sri such and such, which is the defendant company, on the following terms and conditions. Your lordship, then first, QSPL will infuse capital of 3 crore and take 75% ownership in the existing company. Then, my lord, kindly take Roman 3. Roman 2 says QSPL proposes to infuse the above capital in the following manner. Currently, the number of outstanding shares of the company is 1 million, which is 10 lakhs. With the face value of 10, so my lord, 10 lakh into 10 is 1 crore, totaling to the paid up capital of 1 crore. QSPL proposes a share split, whereby split shares will have a face value of rupees 1. So basically what we are saying is 1 crore into multiplied by 1. So the shares will be split up into 1 crore. Then after this split, the current owners of the company, my lord, kindly make a note of this. Current owners being the defendants will have 10 million shares of face value of 1, which is 10 lakh into 1, which is 1 crore per share, totaling to a paid up of 1 crore. Then STPL will then make, that is the defendant will then make a rights issue in the ratio of 1:3. So that means 1 share, after splitting, there will be total 1 crore share. So 3 crore share will be issued. So that means 1, he already has 1, so it will become 3. So he'll have total 4 crore share he will have. The defendant will have.
No, SMPTL will make the rights issue
in the ratio of 1:3. So that means they are 100% shareholders.
Correct.
So once the rights issue is given, so they will become the owners of 4,000 shareholders, 4 crore shares of rupees 1 each. Then this means that every 1 share held by the shareholders, they will get 3 shares of rights issue. Then the current shareholding of STF will renounce the rights totaling to 30 million at 0 value to QSPL. So basically what he'll do is that 75% stake, how will he give? So out of the 4 crore, 3 crore share he'll transfer to me, which is 30 million. So I will become 75%, the 1 crore will remain with him 25%. Then how? Payment. QSPL, which has agreed to subscribe to the rights issue, will make payment in the following manner. My lord, kindly see. Payment on application. So this is the application money for rights issue, 30 lakh. Then, my lord, kindly take the note 1. Payment on first call. Payment on second call, payment on final call. So what
much
we have
amount you have paid?
No, I have paid about 49 lakh, but I was not even required to pay 1 rupee. Because he, under the agreement, he has to initiate the rights issue. Under section 62 of the Companies Act. That is, he has to take a board resolution, take the approval of the ROC and start and initiate the process of rights issue. He has not done anything. But in good faith, I have already given him upfront 49 lakh. And my lord, 49 lakh is not important. What is important is I have given exposed my entire, my lord, technology, people that, my lord, that your lordship will find from the documents. Over the last 1 year, I have infused my expertise, my goodwill, reputation, which is.
Where is the clause that you will infuse?
There is no clause. Now your lordship will see what happens. Then, my lord, kindly take clause 2 once. So this is the rights issue. It is his obligation. He is the shareholder. He is the director. I cannot initiate rights issue. No, my lord, kindly take Roman 9 once. I showed your lordship that money, how it is. Then kindly take Roman 9. It may be noted that the total payment of the right issue will be made within a period of 4 months from the date of rights issue. So if you do not initiate rights issue, how will I make you payment? And there in the letter of termination says that I was required to pay upfront 3 crores. Then, my lord, kindly see Roman 2, clause 2. It has been agreed to make the following changes in the board of directors before the rights issue and infusion of capital. My lord, kindly make the note of the word before.
It has been agreed to make following changes of board of directors, rights of, yes,
Before the rights issue.
correct.
So that means agreement, you are supposed to do that because I get an entry into the company. So I get confidence that I will. So nothing is done. Now, my lord, can you have a look at this? One director from the erstwhile board of directors is to resign, and 3 new directors from QSPL to be appointed. Not done. So this is a prior obligation to rights issue. It may be noted that under the new ownership, we will follow the principle of proportionality for appointment of directors in the company. Then, my lord, kindly take a note of para 3. These are all obligations of the defendants. Clause 3. It has been agreed to make the following changes in the financial control and finance department structure before rights issue and infusion of capital. So, my lordship is in before. Who can do it before? They can do it before. There is no obligation on me. Similarly, your lordship will see clause 4. It has been agreed to have an internal audit conducted for assessing all the outstanding liabilities of STPM before the rights issue infusion of capital. Now, well, I appoint an auditor. Subsequently, the auditor was given, he throws out the auditor. He doesn't give him rest money, doesn't give him exposure, or he doesn't give him access to any of the books and accounts. Now, your lordship will see QSPL to appoint an audit firm to audit. So otherwise, if I don't know your liability on your books of accounts, so because rights issue, I'm investing, I'm coming into the company, I must know what are the liabilities, because the liabilities of the company eventually will come on me as a director, as a shareholder. So, well, kindly see all of these are the obligations. It is all given, all outstanding payment, all payments due to the creditors, loans given to banks. So these are the obligations which was his. Now, my lord, kindly have a look at clause 7 at page 34. It has been agreed that, my lord, kindly make a note, in capital, only a portion of the rights issue fund will be used for the existing and outstanding and urgent payment of the company. So the rights issue money which the company is generating, you cannot use the entire thing to liquidate your dues. You can't even do that. But that you can only do after you initiate the rights issue and I start paying in terms of the rights issue. Thereafter, my lord, there are several other clauses, my lord.
Yes, then?
Now, then what happens, my lord? Then if your lordship kindly comes to page 37.
Yes.
Now, my lord, this is the bank statement which we have disclosed to show how much of money I have paid. My lord, this continues till page 50. Now, my lord, kindly I will just take the trouble of showing your lordship page 51.
Yes.
Lordship will looks at one entry. Payment made to. Your lordship will see these are the payment that I make to them. Well, kindly see on what account have I made the payment. Well, kindly see payment made to Sri Mudranalaya. This is the name of the defendant company, was, of course. Current account. Then, my lord, if your lordship will see, my lord, kindly take page 52. Your lordship will find payments made to share application account. Page 52.
Yes.
Share application account.
Yes.
So he says, now share application account, I am making money. I am making payment. So where is the rights issue? And my lord, he completely denies that payment, I have made payment under share application. And your lordship will be surprised to note, in one of the response to the letters exchanged after termination, he says that I have given a loan to the company.
Who?
The defendant says the money that I have paid, he acknowledges the money that I have paid, 49 lakhs, but he says that the money I have given by way of a loan to the company. And whereas money has been paid under share application money, and my lord, under the Companies Act, share application money cannot be utilized by the company till there's a separate reserve fund for share application. Because share application money has to be utilized by the company for the purpose of issuance of shares. So the rights issue when you are making, you have to justify in your books of the company that this money on the basis of which, my lord, the shares have been allotted. So whether the entire rights issue process, he has not initiated. Why? Because the moment he had issued the rights issue process, that means I will get shares, I will get 75% control of the company. This is he didn't want. In the process, what he has done, in good faith I have done now. Question is, what have I done? Well, allow me to show your lordship what have I done. Now, well, kindly come to once page 60, immediately the page thereafter, page 60. Well, I engage a contract by the name of DAG Consultant.
Yes.
In January 2025.
Yes.
If your lordship will see, just for the purpose, what purpose, if your lordship will take the project background at page 60, it says the client's client, so which is the defendant company, referred to as company A, is engaged in a project of convert approximately 64,000 cadastral maps into shape files by June 30, 2025. Currently, company A's manual processing workflow is such and such, existing workflow. So this, and my lord, compensation is, my lord, kindly see $10,000 for initial research and development. Now, my lord, kindly take from page 60 onwards, all the way till page 190, your lordship will find documents that we have disclosed, which will show that this consulting company has been engaged by me for the defendant company, has been working tirelessly for the last several months. Now, my lord, interestingly, I want to show your lordship one more thing. If your lordship kindly takes page 158 once. There's a lady by the name of Dr. Kaveri Shamanto.
158.
Yes, my lord. If your lordship is looking at the plate, page number,
Yes.
yeah, my lord. Volume 2. If your lordship will see, this is the, she's a doctorate in geotechnology. Now, if your lordship will see a profile, she has been brought in by me. This lady, this is her resume. Now, I'll show your lordship correspondence. Then there is another person by the name of, these are experts in the field of digitization of geotechnology.
You have brought this.
Yes. Then, my lord, your lordship will kindly take another person at page 165. Your lordship will find there's a biodata of one Kazi Hifazat. My lord, kindly see, like Dr. Kaveri Shamanto, kindly see their profile. And your lordship will know that these are experts in this field. So I bring in this person. Then I bring in two more persons, which are at page 166 and 168.
Yes.
And your lordship can find the mails, discussions, what is happening, all with these people who has been brought in by me into the company. That your lordship will find one of the admissions made by them. At page 188, your lordship will see the entire chain of mail. This is issued by the CFO of the defendant company. CEO of the defendant company. Now, allow me to show your lordship a board meeting My lord, kindly take the trouble of coming to page 193 once.
Yes.
My lord, this board meeting is of the defendant company which was held on 27th of February 2025. My lord, kindly take this, my lord. My lord, if your lordship will see, the fourth name present is the name of the plaintiff, Sanjay Agarwal. And he has been recorded as head of finance. Very good. Now, my lord, kindly see. I'll just read out some of the relevant paragraphs. My lord, here they are recording new business opportunities. So this is all because of me. Such and such informed the board that such and such have finalized the rate contract with such and such. Work order for pilot has been received by them and such and such. He further informed that the training of the project scheduled to commence on such and such. The board agreed that Dr. Earth can get associated with the project. Then, my lord, kindly take para 2. It was informed to the board that currently the research work of the automation of the land map is being undertaken in Kolkata and also in the United States. It was decided that these two teams will work independently of each other, and in order to support the US team, few candidates will be shortlisted, and Mr. Sanjay Agarwal will identify two personnel who will be exclusively interacting with the US team. The Kolkata team will be headed by, as your lordship found that name, that is the same name which I showed your lordship at page, I think that was at page 159. What was that page, Kaveri? That
158.
ladies, yes, that
158.
yes, my lord, that same. Thereafter, your lordship will find assisted in the personnel. So she is there on board now. Then, my lord, kindly take para 3. They refer to another company who signed an agreement with them, and kindly see second sentence at para 3. It is understood that Mr. Manoj Keshwan and Mr. Sanjay Agarwal are closely associated with Genesis. That is how you got the contract.
Yes.
Otherwise, you would not have got these contracts. So I am bringing in work. I am bringing in technology. Then, my lord, your lordship will see. So, my lord, there is a unequivocal recognition of my participation in the company by the board as the head of finance. Now, my lord, kindly see what happens. Now, my lord, in fact, if your lordship will see, the company's name was Shri Mudralaya. Now, my lord, kindly see the certificate of incorporation of change of name. I get the name of the company change because if you're working globally, you cannot have such a name which people cannot pronounce. So, my lord, kindly see what we do. I get them to change their name. Then the company's name today is Dr. Earth Technologies. That certificate of incorporation of change of names at page 194. Thereafter, my lord, your lordship comes to the termination notice now at page 195.
Yes.
My lord, at para 1, after he refers to the agreement, my lord, kindly take para 2. He unequivocally admits the fact that under the agreement, so my lord, the agreement is not in dispute, the existence, the fact that the parties have acted in terms of the agreement. So at para 2, he unequally admits that as part of the agreement, it was decided that Quick Advisory will acquire 75% of the shares in such and such through a rights issue. Complete admission. The agreement also referred to various action elements to be undertaken to ensure a positive growth of the company. Then, it was also agreed that USPL will arrange to pay a sum of 3 crore upfront. Again, 75%. This is contrary to the agreement I've shown your lordship. Of the shares being divested, which will permit SMTPL to clear its outstanding dues and other financial commitments. Your lordship recalls clause 7. The share application money can only, the word is only in capital in bold, can only be utilized partly. And what is they say? That they say A, upfront 3 crores, not in terms of the agreement. They say money was required to be utilized for payment of outstanding dues, which you cannot do under the Companies Act. Share application money cannot be utilized in that manner. It is regrettable that till date there has been no response from your end. except some vague indication and assurances of some larger investor will invest in the company. Unfortunately, none of which has materialized. Well, is it not contrary to the board meeting which was held in February? Then we also find that there is no effort made towards business development at all, and the company is missing out on various large GIS projects opportunities, which is highly detrimental to the health of the company. Further, you have failed to remit the rent payable to the landlord, which has been long outstanding, and against which the landlord has issued the eviction notice, which has also been shared.
Yes.
Where does he get that from? No, nothing remotely provided in the contract. Then he doesn't stop here. Like, look at the absurdity of the other grounds. Under the circumstances, we are left with no other option but to cancel the agreement signed. Well, it is wholly contrary to the board meeting.
Prior to termination, any further notice?
No, nothing. Then, my lord, interesting, after this it comes. My lord, kindly now take my reply at page 197. My lord, I first say that you have no authority to terminate under the agreement. This is my response. And then I give reply, factually I give reply that how and why they are wrong in their allegations. So this is my reply, your lordship will find at page 197. Now the interesting part is, then I give a detailed response to my advocate on 20th of June, which is at page 200. Realizing that the termination will not sustain, now your lordship will see the turnaround. If your lordship will kindly come to the response to my advocate's notice at page 208. Well, as they say, my lord, truth has many ways of coming out. My lord, here he admits the payment. Now, my lord, kindly take page 208, which is the response to my advocate's notice.
Yes. Yes.
My lord, kindly take 209 at the third paragraph at 209, where he says, my lord, it was given by way of loan, advance to the company, that 49 lakhs, which I say 45 lakh 96,000. Kindly take the third paragraph. With reference to your contents of paragraph 4, we deny and dispute that the amount of 45 lakh was infused in the capital for the instant 30 million shares or partly paid off shares. The said sum was advanced as loan. My lord, I have shown your lordship that the money was given in share application money. Now they are saying it is loan. Now, my lord, interestingly, my lord, now in the response to my advocate's notice, he says he turns me to a criminal. He says I'm a criminal. Well, kindly make a note of the second paragraph at page 209. Not a word in the termination notice. Now he says I'm a criminal. Well, 25 years back, SEBI had issued a notice. I was a director in another company. There was some deviation in share allotment and share target. So SEBI had issued a notice. He knows about that. So he now, in response, not a word in the termination notice, he says that you're a criminal. So I didn't know about that you're a criminal, so I can't do anything with you. Now the situation is, today, why do I need that protection? Now what he will do is, I am sought for specific performance of this. Now, unless he is at present restrained from changing, because he'll sell it out. Because since he was selling me his shares of 75%, today the market value of the company has gone up. Now, today he will get an investor now who will invest in the company and take up the shares. So unless presently the share structure of the company, well, there should be an injunction restraining from changing the share structure. It doesn't affect their business. If the shareholding pattern remains the same and the directorial pattern remains the same, it cannot affect the business of the company. I'm not saying they should continue, stop the business. Well, this is what I ask for by way of an ad interim prayer. And my lord, no effect should be given to my termination notice. Well, if your lordship will kindly take the reliefs that I claim in my GA application, it would, your lordship will find that at page 24 of my interlocutory application. Aja. My lord, B, A, I have asked for in terms of that termination notice.
A and B.
Yes, my lord. B, I have asked for not to change the shareholding structures.
Yes.
Because today what he does, if he sells out the shares, because he was already entered into an agreement to sell it to me, so tomorrow he can enter into any agreement share. So that means if I get specific performance, it will become a paper decree. I'll never be able to implement that. And my lord, then I have press C. I also have sought for, my lord, an injunction so far as the directorial pattern of the company is concerned. He is a director. Let him be a director. So these are the limited prayers which I seek at this stage. And my lord, your lordship can also make a note, well, this is a non-determinable agreement. There is no clause in the agreement which authorizes any of the parties to terminate the agreement. And the termination in any event is not in terms of the agreement. So the termination, we have also prayed that the termination is void. That's my relief in the suit.
Where is the non-determinable agreement? How you can say?
Well, your lordship will see the agreement itself. No clause to determine the agreement.
Where is that?
No, there is no clause. That's what I'm trying to tell your lordship. If your lordship will seize the agreement, which starts at page 30 of the plaint, there is no clause which authorizes either of the parties on account of breach or otherwise to terminate the agreement.
Condition of termination.
No, there is nothing. So if there is nothing, so
ठीक है 11:30 है क्या बताएं कि नहीं The plaintiff has filed.
Well, may I have your lordship kind leave, my lord?
The plaintiff has filed the present
Grateful, my lord.
praying for a decree, praying for a decree for declaration of the termination of the agreement dated 26th August 2024 and the communication dated 11 June 2025 is void, illegal and unlawful, and consequent reliefs. The plaintiff has prayed for leave under clause dispensation of leave for dispensation of section 12A of the Commercial Code Act 2015. Counsel for the plaintiff ऊपर जो है ना पहले and suit for specific performance of contract, specific performance of the agreement dated 26 August 2024 and declaration and further. Okay. The plaintiff has prayed for leave dispensation of section 12A of the Commercial Code Act 2015. The plaintiff submits that on 26th of August 2024, an agreement was entered between the parties. As per the agreement, the plaintiff has invested rupees 49 lakhs, 9 lakhs, and has appointed several project scientists to complete the project of the defendant. In spite of receipt of the amount, the defendant has not taken any steps, but unfortunately on Where is the termination notice?
Page 195, my lord.
On
Volume
11th of June 2025, a notice of termination and the agreement was terminated by the defendant. After the termination of the agreement, the plaintiff has sent a detailed reply as well as the legal notice has been sent. And in reply to the legal notice, the defendant has admitted that the plaintiff has invested an amount of 45,96,000, but has made several allegations against the plaintiff. Full stop. Counsel for the plaintiff submit that as per the agreement meant after the investment of the amount by the plaintiff, as per the agreement, the defendant will and the as per the agreement, after the investment of the amount, the defendant will initiate further process for transferring of the share and making three defendants of the plaintiff as three persons of the plaintiff as directors in the defendant company. But in spite of receipt of that amount, the defendant has not initiated any process in terms of the agreement. He submits that there is every chance, he submits that if the plaintiff will go for the pre-institution mediation process, in the meantime, the defendant will induct some third party in the defendant company, and the plaintiff will be prejudiced. Peruse the print materials on record and urgency pleaded into present print. This court finds that the agreement was terminated by the defendant on 11th of June 2025. Subsequent to the termination, the plaintiff has sent a detailed reply as well as the legal notice, but the defendant failed to consider the same. And now the defendant is and now there is a chance that the defendant will induct some other third party in place of the plaintiff by entering into fresh agreement. And if at this stage, the plaintiff is not granted dispensation of leave under Section 12A of the Commercial Code Act, the defendant will suffer, the plaintiff will suffer irreparable loss and injury. Accordingly, this court finds that the plaintiff has made out a case for urgent relief, and such urgent relief before without initiation of the pre-institution mediation process. Thus, dispensation of leave under Section 12 capital A of the Commercial Code Act is allowed. Plaintiff is admitted, subject to scrutiny by the number later. The plaintiff has also filed an application for injunction for grant of interim relief. Full stop. The इसको बाद में डिक्टेशन दे देगा अभी आना भाई चैम्बर में आ जाओ interim order का डिक्टेशन. Plaintiff is admitted, subject to scrutiny. Yes, call them please. Yes.
Blood, here I am the opposite party opposing blood the application that my learned friend has taken out. Blood, there's your lordship remembers this matter, Lord. They are not asking for a relief against the cancellation of the power of attorney which my client had granted to them on the ground that it is coupled with interest, therefore it was irrevocable. In connection with that, they are praying for a relief before your lordship so that I do not give any effect to that cancellation of the power of attorney. but they have relied upon two of the judgment which says that in exceptional cases where that the interim relief can be granted, which is akin to the final relief. It was my submission on the last occasion that they do not fall within the exception to say that why this particular interim relief that they are asking for falls within an exceptional circumstance. It was my response, that in the event, based upon a cancelled power of attorney, wherein, the principal and agent, the relationship has been severed, but if they act on that basis and they enrich themselves, there might be a situation which is irreversible in a sense, but my client, the company, they might not get the benefit of the amount which is to accrue to them by virtue of the government paying them out of the acquisition funds. Now, on the last occasion, I have taken your lordship, to the entire the agreement, the power of attorney, that is at there. I pointed out in the power of attorney at page 201 at 205, it was stated that the initial one, the initial power of attorney, the right to cancel was reserved.
Yes.
But there was subsequent creation of power of attorney, again cancellation, and there were certain cancellations. The last cancellation which they pray for is that is the subject matter of challenge before your lordship. Now, the intimation of revocation is at page 333, volume 3. That was dated 12th of July 2021. Now, the division bench's order was also placed before your lordship, in connection with this.
You are in the affidavit in reply.
But I was in the affidavit in reply, in the affidavit in reply, I have, place, page 46, 47, and 48 in the affidavit of reply of Ranoj.
Ranoj, yes.
But that was, I placed on the last occasion. That was, all that, I wanted to say, that if your lordship passes an order, as of today, that will be granting them, the final remedy. And, in the event, they act on the basis of, the power of attorney, which as of today stands cancelled, there will be a chance, which is irreversible, in a sense. Secondly, they do not show before your lordship, that they fall within the exception of the two judgments that they rely upon.
Yes.
That why, in the absence of any, injunction as they pray for, they will suffer irreparable loss and injury.
Yes.
But in this context, I draw my lord's attention to the two judgments, my learned friend has relied upon. But first, your lordship may take up the judgment 2004, volume 4, Supreme Court cases 697.
The judgments का है?
Only compilation of document. So that's a handy compilation of document. That is already there on record. But I have filed a supplementary containing all the relevant documents. That is for the convenience of the court.
Correct. वो क्या नीचे क्या रखा है? नहीं है कंपाइलेशन नहीं है कंपाइलेशन जजमेंट्स बहुत जजमेंट्स थे.
But I have got a copy. I can
assist
your lordship. Kindly take তোর কাছে আছে? আরে এই
judgment
copy আর আছে? দে না. But I'll hand it over. The relevant paragraphs are marked on the top of the first page. এটা কি? ছিল তো যশোর। Oh, supplementary. But your lordship will kindly take up 2004 volume 4 Supreme Court cases.
Yes.
697, the relevant para is para 12. It is written on top,
Yes.
the paragraph that they had cited. This was in the context of 226, but not the principle.
इसमें जजमेंट कहाँ है? जजमेंट सब कहाँ है? प्रिंटेड जजमेंट दिया था दुनिया भर का. Yes.
Your Lordship has taken up 2004 Supreme Court
Yes.
cases. Lord, kindly turn over to paragraph 12 at page 703.
Yes.
The situations emerge where the granting of an interim relief would tantamount to granting the final relief itself. And then there are maybe converse cases where withholding of an interim relief would tantamount to dismissal of the main petition itself. For by the time the main matter comes up for hearing, there would be nothing left to be allowed as relief to the petitioner, though all the findings may be in his favor. In such cases, the availability of a very strong prima facie case of a standard much higher than just prima facie case. The considerations of balance of convenience and irreparable injury forcefully tilting the balance of the case totally in favor of the applicant may persuade the court to grant an interim relief, though it amounts to granting the final relief itself. So, my lord, it is by way of an exception, the parameters are not spelled out. Of course, such would be rare and exceptional case. The court would grant such an interim relief only if satisfied that withholding of it would prick the conscience of the court and do violence to the sense of justice, resulting in injustice being perpetuated throughout the hearing. And at the end, the court would not be able to vindicate the cause of justice. Obviously, such would be a rare case accompanied by compelling circumstances where the injury complained of is immediate and pressing and would cause extreme hardship. The conduct of the party shall also have to be seen, and the court may put the parties on such terms as may be prudent. So, my lord, the judgment that they have cited has itself not enumerated not under what circumstances it can be granted and the checks and balance to be put in.
Yes.
Now, my lord, the other judgment that was relied upon, my lord, that was a division bench of this court, my lord, at paragraph 38, 2005 SCC Online, Calcutta 342.
Yes.
It's equivalent to 2005 volume 4, Calcutta High Court Notes, page 14.
Yes. Para 38.
Para 38, my lord, that is an internal page 5.
Yes.
The other point on the basis of which the learned judge has dismissed the application is that the order sought for was in the nature of main relief by way of an interlocutory application. It is well settled that in given circumstances, court can always pass interim relief in the nature of final relief, though such a power is required to be used sparingly and with utmost caution, but it cannot be contended that the court is precluded from passing an order in an interlocutory application which would result in granting a final relief. So the principle is now not well settled about this. So, Lord, this judgment itself, which they rely upon, Lord, I say that, Lord, the facts that are before your Lordship, Lord, that doesn't make out a compelling circumstance of grant of the relief, Lord, that they are asking for in the interlocutory application as of now.
Yes.
That's so that is all from us.
Thank you.
Then we'll have to come back tomorrow, my lord. Then your lordship has already fixed it tomorrow. Yes, that is already fixed.
It's fixed at 11:30 tomorrow. Also.
I'll come back tomorrow. Problem is your lordship's court is vacant. The problem is the court is vacant.
They asked me whether it will continue till 12:30. I told them that it will continue. That was my mistake. The another matter is fixed at 12:30. I find, bro. That's the reason.
The counsel for the defendants has concluded his argument in connection with GA1 of 2021 with regard to the interim order. Counsel for the plaintiff is for time. The matter is already fixed tomorrow at 11:30. Let the matter appear tomorrow at 11:30.
Much grateful.
Thank you. Yes, call the matter. Order item number 9. मॉर्निंग में खत्म हो गया तो कौन वाला 6 नहीं तो 6 क्या है अच्छा वो 9 The matter was listed on 19th March 2025, but none appears on behalf of 19th March 2025, and as per the prayer made by the counsel for the plaintiff, this was adjourned till 21st of April 2025. The matter was again listed on 17th of June 2025, but on the date fixed, none appears on behalf of either of the parties, and no accommodation was sought for. Accordingly, the matter was placed in the list of in the warning list. Full stop. Even after placing the matter in the warning list, the matter is placed before this court today, and when the matter is called, none appears on behalf of either of the parties. No accommodation is sought. Considering the above circumstances, this court finds that the plaintiff is not interested to proceed with the matter. Accordingly, CS-Com 777 of 2024 within bracket old CS number 240 of 2017, Elite Interiors Private Limited versus Oriental EPC Private Limited is dismissed for default. Interim order fine is stand vacated. Next.
My lord, Mr. Shantan Basu is leading us in this matter. He is not available today due to some personal difficulty. Kindly make it not today and keep the matter tomorrow.
Which was the defendant? Yes.
Let a vector paper. The respondent defendant. My lord, on last occasion.
You are appearing for the defendant?
Yes, my lord.
Yes.
Last occasion, there was a direction to file and disclose an explanation affidavit. We have done so, my lord. I believe the plaintiff has also come up with a reply. I believe that is before my lord today. Now, my lord kindly takes up the reply as on date what the plaintiff is actually seeking.
Where is your affidavit? Where is your affidavit?
My lord, we have been served.
It has been served.
Your affidavit?
Our explanation affidavit has already filed.
Served.
When you filed?
11th, my lord.
11th of?
11th of September. 11th September, my lord.
Where is it? Where you filed?
My lord, before the concerned department.
Yes.
Yes, my lord. Now, all said and done, my lord. Kindly considers what the plaintiff today is actually seeking for.
No, what is the explanation?
Yes.
First, you tell what is your explanation by removing the notice.
Regarding removing a notice, as per the director, they have denied that they have done so. They have no knowledge regarding the same. And in the same note, my lord, they have also said that the keys, the original keys of that particular shutter, it was long before the plaintiff came up, even before that the surface proceeding initiated, shutter was put under lock and key by the plaintiff defendant itself, and the keys are with them still date.
With whom?
With the defendant director, my lord.
Defendant's director?
Yes, my lord.
He is with them?
Yes, my lord. It is with them. And
okay, I am passing an order for investigation. Who has removed that?
My lord, before.
I am investigating because first question I put, you have given the specific answer, your client has not removed. And the key is with you.
Key is with
so
us.
let the police investigate. Registered an FIR and investigate the matter. You cannot play with the courts. No?
Absolutely not, my lord. We are not.
On affidavit stated,
yes,
what is accepting that? Let the police investigate through the CBI, not the local police, through the CBI.
With the deepest respect, my lord, kindly. what today the plaintiff also seeking kindly considers that as well.
I will not. First of all, you satisfied who has removed. If you admit, then I will go further. If you will not admit, then I will matter sent to the CBI.
My lord, with regard, my lord kindly takes the paragraph number 4, my lord.
Yes, I have read. You have stated that you are not removed.
Yes, because
Yes.
that is with regard to this particular.
The special officer is false. Before the special officer is, you are not challenging that report.
Special
No,
officer
because
has
we did not receive that report, which was handed over on last occasion only, and we have got only the
So
scope
you are
of
not denied
explaining,
that,
my lord.
denied with regard to that report. Let the client face the consequence of the false affidavit. Then I will consider other papers.
My lord, with the deepest of respect, my lord, if
I know when you appeared before this court and taken the time for filing affidavit, I appreciate. I found yes, you will come with this affidavit. But I am giving an opportunity so that your affidavit come on oath. That's why I given an opportunity that has come, which I was suspecting.
even that, so we have already mentioned that before. I have already stated to the defendant itself. My lord, they have already come up with the disclosure that the keys are also with them, and they are ready and willing to hand it over because the inventories are still. We are also with an apology that if they have inadvertently made any mistakes,
Okay,
for that my lord considers paragraph 6 as well, my lord.
because they are the businessmen, let the CBI investigate. I see how they will get the contact and how they will do the business.
My lord, that business is already.
I will record that. No render should be awarded.
The
And that
company
will
is
be published
already.
in the paper, and the CBI will investigate the matter and submit the report before this court. Though this court is a civil court, but submit the report before this court.
My lord, with the deepest of respect, my lord, kindly.
How dare you file the affidavit on oath?
My lord, they have also apologized for an
What apologize? After giving an affidavit, you are apologize.
in the affidavit itself, my lord kindly considers that.
You
And
have
also-
given an affidavit, you are not removed, and you are asking the apology. This is the way. One paragraph you are telling that you have not removed that notice. Second paragraph, apology.
Because with regard to the office or the space that
Who
is
has
there-
given this advice? You have given the advice.
No, absolutely not, my lord.
You have drafted.
Absolutely not.
Who has drafted this?
My lord, that is, I think, my lord, I believe.
And you are appearing advocate. You have not gone through the contents of the affidavit because it's filed before the High Court.
My lord, after going through
So
the
you are
affidavit
given the
only-
advice. Yes, you file it. I will save you.
They have not, absolutely not, my lord. This I will never do that. I'll never do that, my lord. That is why
When your client will be able to appear before this court, tell me.
that could be done.
Tomorrow. And I will call the police also. Which police station?
Tomorrow, I myself is not there, my lord.
You're not, your presence is not, I am not required your presence. I required your presence and the police person, who is the concerned police officer who can take the custody of this person. From here only.
The place is at Bidhannagar.
Huh?
The place is at Bidhannagar. Probably it is under the
I will
Bidhannagar.
call the officer in charge or the superintendent of police also depute the police person. So your client should be taken
My
from
lord,
here
as
only.
per my instruction, my lord, I received just now. My lord, he is now at present not in Kolkata. He is at the.
Maybe I want tomorrow with
This
24 hours.
submission can't be allowed.
I am giving the
Previous day they have
24
also
hours.
submitted
Tomorrow
this.
at 12:30 he will be here.
My lord kindly considers that.
I considered, all the considered. I already considered.
Because I believe
It is
that
up to you. Tomorrow at 12:30 your client is here. I will give, otherwise I have to pass.
Day after tomorrow, my
No,
lord.
no,
Kindly-
no, no, no,
kindly
no,
day
no.
after tomorrow gives an opportunity to
No,
calm
no,
down. my lord.
tomorrow
It's
you
already-
come, you have to come here.
Yes, my lord.
After this
that
con-
Tomorrow 12:30.
That depends on day.
My lord.
Will come down, my lord, day after tomorrow.
Not
Kindly.
tomorrow, sorry.
Bro.
Come tomorrow.
Of respect, my lord. Kindly keeps it day after tomorrow.
How dare you file this application affidavit?
I have.
On that
I
day
have-
you have seen the mood of this court.
Yes.
After
no
going to
doubt.
the report,
I have communicated
and
whatever is happening.
I already given the hints to you.
Yes. I have already communicated.
Affidavit should not come. Again, you file the same affidavit.
I did, my lord. I bow down. I have communicated this to them. In
And
spite
but
of that,
you are appearing. If your
Yes,
client
yes,
is
yes,
why your client is not adhered to your
They have-
request?
this is- I
Who is the advocate on record?
some
Call him.
Amortyo Basu, my lord.
Call him. Call the advocate on record. I will see how this court is not bear of this type of the affidavit,
Absolutely
sir.
not, my lord.
And let the advocate on record come here. Call, immediately call.
My lord, allow.
You are the officer of the court.
Absolutely, my lord. I have time and again have told them what has happened. Actually, come up with this. They have said there are two properties, my lord. This is a shop property.
Whatever it is, I am not property, I am not execution, I am not the order. I am only with regard to your statement here.
Yes, yes.
And
my
the
lord.
statement made before the special officer, which a special officer submitted the report. I am considering this. You satisfied this?
My lord, we take the reports, my lord.
Once paragraph you are telling that you are not removed. Second, you are apologize.
For any inadvertent,
Ah.
yes, my lord.
So,
Because
if you have not done anything, why you are asking for the apology?
because my lord, the client has. My lord, kindly takes up. There are three reports, my lord. My lord is seeking explanation regarding report number 2, my lord. My lord, you find in report number 2, there are two properties, my lord. One at paragraph 11, that is this office property, my lord. And then it proceeds to paragraph 13, that is the flat. Now, after that, paragraph 14, my lord, the special officer inquires the director's answer that the same was removed by them, such and such. Information was not given to the removal of that, my lord. My lord, will consider the reply affidavit, my lord, now. It has come up with regard to the office space because it is not visiting it and already been surfaced and Kotak Mahindra Bank has taken position and so forth. My lord, in fact, in the reply affidavit also, the plaintiff has come up with this similar governments and seeking further disclosure of the affidavits and the status of the surface. We are already carrying that, and we were also hoping that by an affidavit will come up with this, so that ultimately today their purpose is to secure the outstandings. I love the properties with them. I believe with the court itself, and the surface proceedings are also there, and in fact the defendants are also before my lord. So, my lord, I am instructed the advocate on record is Bankshal Court. My lord, he's on his way, my lord.
Record and order. The alleged contemner. Who has filed this affidavit? Only one.
Only one of the directors, my lord. It was the direction, my lord. Like, kindly takes the last order.
The alleged contemner, namely Anjan Kumar Das, being the director of the defendant company, has filed the affidavit on 11th of September 2025, wherein he has stated on oath that where is the statement? Stated that he has no knowledge of anyone, other than him or any other directors having removed the purported possession notice from the premises, and if anyone, other than me or any other directors of the defendant company has actually removed such person notice, I am completely clueless and in absolute darkness with respect of the said incident. The said statement of the alleged contemptor report का है? Follow.
My lord, with your kind leave, we are filing the
Wherein
affidavit.
No, full stop. Full stop. In the report dated 9th June 2025, the special officer has categorically stated in the report at paragraph 4.14.91 14, which reads as follows: I am again found that the earlier notice pasted by me was removed, full stop. I had provided a copy of the order dated 16th April 2025 to the directors and inquired who had removed the earlier notice of symbolic possession, full stop. The directors answered that the same was removed by them, but it is pertinent to mention that no such information given to me before the removal of the notice, nor was any leave taken from the Honorable Court before such removal of the notice. The statement made by the alleged contemptor, Mr. Where are the other directors?
Another director is the wife of the defendant.
Where is our affidavit? Because he has alleged other directors might have been removed. So he don't know why wife has removed or not. Can you see paragraph? Read the paragraph 4. Might be other directors. So you want that wife should go. The other directors having removed the purported notice. And purported notice. How did? Where from got this purported notice? So notice issued by the court would be a purported. You being the senior person appearing. This is a notice of purported.
My lord, this should not have gone.
Huh?
This should not have gone.
So?
Absolutely. And I take up the bonus, my lord.
You continue with this affidavit?
No, absolutely not. I wish to withdraw and file a fresh affidavit with both that defendants, my lord. Kindly grant me that. For both the directors, my lord. I wish to.
How you can say the purported notice?
Absolutely not. This should not have gone. I take up the bonus. Being the counsel, I have to.
Though the alleged contemptor, namely, Anjan Kumar Das has filed the affidavit, but now the learned counsel appearing for the alleged contemptor prays for not pressing the said affidavit and prayed for leave to file a fresh affidavit of both two directors. Both directors. Let the said affidavit be filed by tomorrow.
My lord, kindly makes it all the directors, my lord.
By all directors. By all directors. By आज कितना तारीख है? By 24th September 2025, after serving the copy to the land counsel for the decree holder plaintiff, let the matter appear on 25th.
My lord, one thing we need to say, they have tried to create an impression that as if the property we are concerned about, the unit FNG flat of Merlin Garden Lakeview, it is under encumbrance due to the proceedings ongoing before the DRT, because they have given the Kotak Mahindra Bank has given a notice that it is under them. But we in our affidavit in reply in page number 64 has provided details of Sarshai details, where my lord will see that nowhere it is written that the property is under equitable mortgage or under encumbrance. And now they are saying, though they have not produced, that they have brought the relevant papers.
Affidavit.
So my lord, in that case,
with regard to this also, we wish to affidavit in reply filed by the.
In that case, my lord, if possible, the bank authorities be called to provide the details.
If there is an explanation to this, then after that I am already seeking submission. That is why I was relying on their reply itself. Whereas
No,
the paragraph, the same
what
thing
they can-
I am also making a submission on that today. Let me be given an opportunity of coming up with an affidavit in reply opposition with disclosing
When
all
the
these.
court officer is going,
Yes.
when the police is going, you are not taken the care of the court notice. When the court has
And
taken
they are calling it purported notice.
mentioned action, now you are aware of that. Now you want to made all the explanation before the court.
No, my lord, kindly.
In fact, I
That is the first day you are appearing.
no, I have already disclosed in the affidavit also, which I have withdrawn.
Special officer thrice he has visited,
Yes.
and you are playing in by sitting in the room.
Right, we wish to disclose all this. Whatever the
My-
plaintiff
That
asked
was
for,
my lord.
the affidavit.
yes,
My lord,
we shall come back.
my lord,
Grateful.
one direction is required from the court, because they can, this is outside the purview of RTI. Then they can take this point.
Yes.
That
Next.
is why we are saying.
I am for the petitioner, my lord. I am for the plaintiff, my lord.
Yes.
The application has been filed by the respondent, my lord, for addition of.
Have you filed the affidavit in reply?
Yes, my lord. I have filed the affidavit in reply.
Ah.
They have filed the rejoinder. Today, the matter is fixed for hearing, my lord.
Hearing of?
Hearing of IA application, my lord.
Huh?
IA. Yeah.
What is
The
the application for?
The application.
What is the prayer?
Ma'am, my lord, I am for the respondent. My senior counsel is not present. She is in personal difficulties. She cannot come today. Kindly adjourn.
As per the, you are appearing for?
Respondent.
I am dismissing it. Your counsel is not able to come before this one. Either you submit or I am dismissing. Who filed this application?
They have filed
Then
this
I am
application.
dismissing it. Your counsel will remain in the house.
She is personal difficulty.
Maybe. I have so many personal difficulty, but I am holding the court. Why you accepted the brief? You are having the personal difficulty? Not to accept the brief if you are having any personal difficulty. There are 45,000 lawyers out there in the bar association. They will be benefited. But I am dismissed, then your counsel when come out from the personal difficulty, then she will take appropriate steps.
My lord, kindly adjourn this week.
As per the prayer made by the counsel for the defendant, case is adjourned. Let the matter appear in the combined monthly list of December 2024. Yes, next.
Item number 12. 12, my lord. I am appearing for the defendant, my lord. But I had taken out an application, my lord, that this suit is not a commercial suit, my lord. We had finished our argument, my lord. We had distinguished the judgment of T. Thompson, my lord. Mr. Mukherjee, the other side was supposed to submit today, my lord. We had
Yes.
Lordship, I'm being led in this matter by Senior Advocate Devajyoti Vasu. He is on his leg before a different court. Lordship,
Every advocates are on leg. Without a leg, nobody can move.
kindly give a short pass over, Lordship.
Every advocates are having leg. Without leg, any advocate you have seen. In the court. Every advocates are on lag.
It's engaged. Kindly give us a short pass over, Lordship.
Come in the December. Who has filed this application?
This is our application. We had completed. They were supposed to submit.
He'll be here shortly, Lordship. Kindly give us a short pass over.
As per the prayer made by the counsel for the plaintiff. For the plaintiff.
Yes, for the plaintiff.
As per the prayer made by the counsel for the plaintiff, let matter is adjourned. Let the matter appear in the combined monthly list of December 2024. Next.
I appear for the respondent number 1. So that application which had been taken up 2-3 times before, Malad.
My plaint, my lord. There is one issue, my lord. In this plaint, they have made, my lord, 2 applications. There are 2 plaints, my lord. They have made a section
2
8.
plaints, 1 case.
No, this matter and the next matter. So 2 section 8 applications, my lord, they have filed, saying that this matter or this subject matter may be referred to arbitration. Now, my lord, I have made an application saying that let that application be taken up and appropriate prayers be passed. Because what is happening, my lord? On one hand, my suit is pending. On the other hand, my lord, the application, my lord, is the arbitration is also proceeding, my lord. Yes, this is what is happening. They are not moving their section 8 and arbitration is proceeding.
Who has initiated the arbitration?
Us.
How many arbitration is there?
Malad?
How many arbitration proceedings are there?
One.
One.
Arising out of one agreement.
And
And
this
this
is another
arbitration
one.
has been going on since 2009. They
And
could have
this-
taken this point.
This suit is also connected with that agreement?
Yes. They have filed these suits after we invoke the arbitration clause and we send them the section 21 notice.
My case before your lordship is that the
It's a
issues,
counter-
admittedly, their section 8 application will reveal that they are saying that the issues in the arbitration and here, my lord, are the same. Now, if that is the case, my lord, then a decision has to be, my lord, passed whether this matter can be referred or not. Now, my lord, both ways, my lord, I can't be cut. My lord, double-edged sword. My lord, every day my client, my lord, is paying, my lord, 1 lakh for an arbitration. I have, my lord, filed this proceeding where the issues are common. So, my lord, I have come with your lordship, my lord, kindly see my prayer. I am not,
GA5.
yes, GA5, my lord. kindly see-
GA5. Huh.
Section 8 be filed on directing the
Section 8.
How can that be, Malad?
This is what I'm saying. There are, I have judgments which I intend to cite before your lordship to show that our division bench has, my lord, if not today, my lord, another day. I have no hurry. That prima facie I will show, my lord, and I want an order, my lord, saying that, my lord, the issues are, the facts are same. If they are same common issues, my lord, the arbitration cannot be proceeded with. Because primarily, my lord, defendant number 2, which is Indian Overseas Bank, my lord, is not a party to the arbitration proceedings. Indian Overseas Bank is a relevant party, is a necessary and proper party, my lord, who is required in the arbitration. For those
But in the arbitration.
for the decision, my lord, to be taken on the issues which are common, he is a necessary party. So in that case, my lord, a private forum, my lord, is perhaps not the best option. Anything which is apart from the suits, my lord, let the arbitration, my lord, carry on to that extent. Whatever, my lord, is to be decided in the suit, my lord, that has to be, my lord.
What is the stage of the arbitration?
At final arguments, and this is the 5th arbitrator. This arbitration has been going on since 2009. The first arbitrator passed
Kindly
away.
imagine, my lord, the amount of financial
We
burden
have
I
been
have
following
had
the
to, my
arbitration, my
lord,
lord.
for
It's
these
very
years.
apparent. And they
Now,
have made
Okay, do one thing. I am fixing a cyanide and let that arbitrator maybe complete that arbitration process.
Yes, my lord, absolutely, my lord.
No, that can't be. Let me, my lord, cite one
The arbitration clause arises, the arbitration
judgment, my lord, which says if the issues are same, my lord, in a similar situation, where, my lord, the one of the defendants, my lord, was not a party to the arbitration proceeding, the division bench said that arbitration can proceed, but in a truncated manner, leaving aside the issues that are part of the suit. So if that order your lordship passes, my lord, I have no difficulty. That leaving aside, but I will show there are common issues. If there are common issues, my lord, kindly see this order.
Common issue
With the suit and the arbitration.
That's because they have filed the suit after we invoke the arbitration clause. Naturally,
You
this is
have
the
filed the suit.
counterblast.
You have filed the suit.
suits.
Correct. You have filed a suit and already arbitration is going on.
Yeah, section 8.
No, you filed the suit.
They have
Prior to the suit, arbitration is going on. Correct. And you filed the suit before this court. You are telling that you have no objection if this court refer the matter to the arbitrator.
I'm not saying that. I'm
Ah.
saying if it is referred, leaving aside the issues here, and I have not filed a
How it can be? Partly, how it can
How
be?
can that be, my lord?
Which judgment you're Sukanya, you go to the Sukanya holding?
No, not Sukanya.
No, you go to the Sukanya holding with that. What the Supreme Court says? Two
Cannot bifurcate. But before judgments, my lord will allow me to at least face some facts. I mean, before your lordship makes.
No, I am. What is my concern? You aware of the arbitration proceeding, and you file the suit here.
No,
If-
not after that. 2012, my lord, after the before the amended statement of claim is filed.
Whatever it may be.
Where-
Now, if you telling that you can make this claim also, can you make before the arbitrator? Why you not file the supplement claim before the arbitrator?
Application before the arbitrators already for staying the arbitration
Arbitrator is saying get an order from court.
Not staying. If your claim is in terms of the agreement, you go and file a supplementary claim before the arbitrator.
Milord, we can't because the bank is not a party. Milord, kindly, Milord, may I just.
Okay, come.
I'll come back.
My
to
fixed matter is there.
Yes. Milord, after vacation. Milord, will allow me at least some time to impress upon your lordship.
Milord, this is a completely misconceived
No problem,
application.
I
my
will
lord.
allow.
Yes.
Because I am not making some prayer.
As per the,
Not
due to
tenable.
paucity of time, hearing could not be completed. According cases adjourned. Let the matter. Counsel for the plaintiff has argued the matter for some time, but due to paucity of time, hearing could not be completed. According cases adjourned. Let the matter appear on
No, sorry, dates.
13th November.
13 November.
13th November.
And that day, Milord, will please hear me out. Mr. Ratnamko Banerjee is on the other side, Milord.
Yes.
I am very scared, Milord. I'll be crushed by the burden, Milord. So, Milord.
During puja vacation, you take this file and sit the whole day and prepare to counter Mr. Banerjee.
To satisfy your lordship. I can't be crushed by weight. That's all.
No.
Milord,
On merits
this
also.
is Milord.
What you file?
Notice of motion.
Notice of motion क्या है यहाँ में?
Notice of motion and service affidavit of service.
Notice of motion and affidavit of service we kept it there.
And it.
Yes.
My lord, on the last occasion I had placed
Section
the relevant
63.
section 63. Now, my lord, I would like to rely on three judgments. Well, the first one is 2002, volume 2, SCC, page 84.
Yes.
My lord, I have already submitted before your lordship, my lord, under section 63 of the Succession Act, my lord. What does a propounder need to prove, my lord? First, that the testator had the capacity of making the will. The signature was that of the testator, and there were two attesting witnesses who have seen each other sign and the testator sign the will. Now, Lord, if thereafter in the caveator raises any question of fraud or undue influence, the onus shifts on the caveator to bring on record evidence and prove that his case is sustainable, no, my lord. My lord, judgment টা দিয়েছে?
Yes.
My lord, 2002 SCC, volume 2. My lord, your lordship will take up paragraphs. It's a judgment passed by Justice Lahoti. My lord, paragraph 8 onwards. আমি দিয়েছি?
Yes, yes.
My lord, may I place this? The requirement of proof of a will is the same as any other document, excepting that the evidence tendered in proof of a will should additionally satisfy the requirements of Section 63 of the Indian Succession Act 1925 and Section 68 of the Indian Evidence Act, my lord. After considering the matter before, that is, the fact and circumstances as emanating from the material available on record of a given case, the court either believes that the will was duly executed by the testator or considers the existence of such fact so probable that any prudent person ought, under circumstances of that particular case, to act upon the supposition that the will was duly executed by the testator, then the factum of execution of will shall be said to have been proved. The delicate structure of proof framed by a judicially trained mind cannot stand on weak foundation nor survive any inherent defects therein, but at the same time ought not to be permitted to be demolished by wayward pelting of stones of suspicion and supposition by wayfarers and waylayers. My lord, the quotation given, the mind was apt to make a pleasure in adapting circumstances to one another and even in straining them a little, if need be, to force them to form parts of one connected whole. The more ingenious the mind of the individual, the more likely was it, considering such matter, to overreach and mislead itself to supply some little link that is wanting, to take for granted some facts consistent with it, previous theories, and necessary to render them complete. The conscience of the court has to be satisfied by the propounder of the will, adducing evidence so as to dispel any suspicion or unnatural circumstances attaching to a will, provided that there is something unnatural or suspicious about the will. The law of evidence does not permit conjectures or suspicions having the place of legal proof, nor permit them to demolish the fact otherwise proved by legal and convincing evidence. Well-founded suspicions may be a ground for closer scrutiny of evidence, but suspicion alone cannot form the foundation of judicial verdict, positive or negative. Now, my lord, if I may pause here. My lord, I have taken your lordship through the evidence. I have proved what as per law is required for the propounder to bring before the court and proved. And in my respectful submission, my lord, the onus has shifted. I have complied with the requirements, that legal requirements under the Evidence Act and the Indian Succession Act, and I have brought to the notice of the court. My lord, your lordship will recollect that while cross-examining my witness, they have admitted the signature. Now let the next paragraph. It is well settled that one who propounds a will must establish the competence of the testator to make the will at the time when it was executed. The onus is discharged by the propounder, adducing prima facie evidence proving the competence of the testator and the execution of the will in the manner contemplated by law. My lord, while the propounder was giving evidence, she has clearly stated that the testator was in perfect mental and physical health. He was carrying out his professional duties, and carrying on arbitrations, consultations. So, my lord, the mental condition, ability of the testator has been established, my lord. Even the attesting witness and the custodian, or if I may use the word scribe also, because he came to the box and said that he was the one who had prepared the will at the instruction of the testator, my lord. All three of them have come to the box and said that they were connected with the testator on professional relationship, and all three of them were carrying out professional work with the testator at the time when he had made the will.
Yes, next.
The contestant opposing the will may bring material on record meeting such prima facie case, in which event the onus would shift back to the propounder to satisfy the court affirmatively that the testator did not know well the contents of the will and in sound disposition capacity executed the same. My lord, I have taken your lordship through the cross-examination of my learned friend, and there is not one single question from which he has rebutted the evidence which has gone in. The factors such as the will being a natural one or being registered or executed in such circumstances and ambience as would leave no room of suspicion assume significance. If there is nothing unnatural about the transaction and evidence adduced satisfies the requirement of proving a will, the court would not return to a finding of not proved merely on account of certain assumed suspicion or suppositions who are the persons propounding and supporting a will, as against the person disputing the will, and the pleadings of the parties would be relevant and of significance. My lord, these are the paragraphs I am relying on in this judgment, my lord. And I have taken your lordship to the pleadings also.
Yes.
From the pleadings also, there is nothing on record which would at least raise a question in the mind whether the will was a proper or properly executed will or not, my lord. The next judgment, my lord. Is my lord 2005, volume 2005 volume 2 SCC 784, my lord. আমি কি করব?
Yes.
My lord, I would be relying on paragraph 11 onwards, my lord. It is well settled proposition of law that mode of proving a will does not differ from that of proving any other document, except as to the special requirement of attestation prescribed in the case of a will by section 63 of the Succession Act. The onus to prove the will is on the propounder, and in absence of suspicious circumstances surrounding the execution of the will, proof of testamentary capacity and proof of signature of the testator as required by the law need to be sufficient to discharge the onus. Where there are suspicious circumstances, the onus would again be on the propounder to explain them to the satisfaction of the court before the will can be accepted as genuine. Proof in either case cannot be mathematically precise. Sorry, my lord. Precise and certain, and should be one of satisfaction of a prudent mind in such matters. In case the person contesting the will alleges undue influence, fraud, or coercion, the onus will be on him to prove the same. As to what other suspicious circumstances has to be judged in the facts and circumstances of each particular case, my lord. Next paragraph, my lord. In the light of this well-settled proposition of law, we have to examine as to whether the will under consideration had been duly executed and the propounder of the will has dispelled the suspicious circumstances surrounding the will. The next paragraph, the propounder of the will has to show, paragraph 14, my lord.
Yes.
Has to show that the will was signed by the testator, that he was at the relevant time in sound disposition state of mind, that he understood the nature and effect of disposition, and he put his signature to the testament of his own free will, and he had signed it in presence of two witnesses who attested in his presence and in presence of each other. Once these elements are established, the onus which rests on the propounder is discharged. My lord, if I may respectfully submit this, my lord, I have discharged the legal requirement which is provided under the law. The DW2, the scribe, in his testimony has categorically stated that the will was scribed by him at the dictation of the testator. Now, my lord, in my case, it is a bit different. It was prepared by somebody who was the custodian, and he was brought to the box by the defendant, and he has adduced his evidence. My lord, your lordship has seen that what he has deposed could not be rebutted by way of cross-examination. The two attesting witnesses have deposed that the testator had signed the will in their presence while in sound disposing state of mind after understanding the nature and effect of disposition made by him. Had he signed the will in their presence, they had signed the will in his presence and in presence of each other. In cross-examination, the appellant failed to elicit anything which could persuade us to disbelieve their testimony. It has not been shown that they were in any way interested in the propounders of the will, so that on their asking they could have deposed falsely in court. Their testimony inspires confidence. The testimony of the scribe and the two attesting witness is fully corroborated by the statement of the handwriting expert. The will runs in 6 pages. The testator had signed each of the 6 pages. The handwriting expert compared the signature of the testator with his admitted signature. He had opined that the signature of the will are that of a testator. In our view, the will has been duly executed. Now, in my case, my lord, while the evidence was being recorded, no steps were taken. First of all, my lord, this ground of forgery was not seriously contested by the defendant. A mere one-liner was there in the written statement, but there is nothing in the evidence in support of that. Secondly, while he was cross-examining the attesting witness, the propounder, and the scribe or the custodian of the will, my lord, not one question was put to any of them that the signature was not of the testator. On the contrary, I have shown your lordship that they have admitted the signature of the testator. Thereafter, after completion of their argument, with a view to put a spanner in the proceeding, my lord, to delay after completion of their argument, and after we have started our arguments, they have come up with an application for appointment of a handwriting expert, my lord. Your lordship knows an application for handwriting expert is not mandatory, and even if it is made, it has to be made under the in the manner which is laid down in section 45 of the Evidence Act, and it has to be made at the earliest. My lord, after the trial is over, Lordship knows, after trial is over and after the arguments are, their argument was completed, then they come up with this application, which in my respectful submissions cannot be entertained. My lord, I am relying on a judgment being 2013 volume 14 SCC, my lord. It is more on the principles. My lord, section 11 onwards, my lord. Paragraph 11, sorry, my lord. My lord, page 1. 2013, volume 14, page 1. Even after considering the principles laid down in Vadiraj Nagappa versus Nagappa such and taking note of section 151 of CPC, this court concluded that in the interest of justice and to prevent abuse of the process of the court, the trial court is free to consider whether it was necessary to reopen the evidence, and if so, in what manner and to what extent. It is observed that the evidence should be permitted in exercise of power under section 151 of the code. The following principles laid down in that case are relevant. We may add a word of caution. The power under section 151 or order 18 rule 17 of the code is not intended to be used routinely merely for asking. If so used, it will defeat the very purpose of having the various amendments of the code to expedite trial. But where the application is found to be made bona fide and where the additional evidence, oral or documentary, will assist the court to clarify the evidence on the issues and will assist in rendering justice, the court is satisfied that non-production earlier was for valid and sufficient reason. The court may exercise its discretion to recall the witness to permit the fresh evidence. But if it does so, it should ensure that the process does not become a protracting tactics. The court should firstly award appropriate cost to the other party to compensate the delay. Secondly, the court should take up and complete the case within a fixed time schedule so that the delay is avoided. Thirdly, if the application is found to be mischievous or frivolous or to cover up negligence or lacuna, it should be rejected with heavy costs. With these principles, let us consider the merit in hand. The perusal of the material placed by the plaintiff, which are intended to be marked as, my lord, I need not go into this. My lord, Lordship will take up their application once. What has been, whether they have made out a ground. What is the ground made out by them?
Okay. Yes.
Lordship, page 2 of the application. This is an application on behalf of the defendant under section 45 read with section 73A of the Indian Evidence Act. Corresponding section 39 it's not required. For appointment of handwriting expert, and the applicant herein is the defendant in the instance suit pending at the moment before this court. The issue in the present case involve examination of the authenticity and or veracity of certain documents, signatures or writings that are critical to the outcome. That in order to resolve the disputes concerning the genuineness of the document, it is imperative to conduct a forensic examination by a qualified handwriting expert. The applicant seeks the appointment of an handwriting expert. In such circumstances, I am skipping this part, Malad, that in such circumstances, the purported unregistered will containing the disputed signature of the testator may please be sent for forensic examination, Malad, subject to correction, Malad. There is not one single ground as to why this application is made at this stage. Not one single ground. Why this application could not be made at that point of time. My lord, paragraph 15. Hence, for the aforesaid reasons, the disputed signature, full and initial of the testator on the purported will must be sent for forensic. My lord, this deed of conveyance was brought on record, a copy of it was brought on record at the time of cross-examining the propounder. Well, no, it was not officially disclosed, and even if it was not disclosed, the defendant had ample time to bring it on record and by presenting it before the court, my lord. My lord, say that apart, my lord, there has to be some ground as to why, what was the reason which was holding them from making this application at that point of time? Why they could not come up before this court for appointment of an handwriting expert when the evidence was going on? No explanation whatsoever.
Yes.
The document was brought on record by the defendant while cross-examining the propounder. After that, 4 witnesses were brought to the box.
Yes.
No steps taken, no reason given. Now, my lord, at this belated stage, when the evidence is complete, the trial is over, we are at the argument stage. Final arguments are on behalf of the defendant completed. It is recorded by way of an order, my lord. My learned friend has not challenged that. Your lordship will find that on 10th of December 2024, the matter fixed for argument today, learned counsel for the defendant has argued the matter at length and prayed for adjournment for further argument. Thereafter, my lord, this was taken up on 13th of January 2024. 25, my lord. The counsel for the defendant has concluded his argument and submitted that he will file written notes of argument in course of the day. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. My lord, after filing the written notes, he had argued for 2 days, completed his argument, filed his written notes. Thereafter, he comes up with this application. And without any cogent reason or ground set out in the application, my lord. My lord, that is all.
Thank you.
Lord, may I place paragraph 15 of the judgment, my lord? From 14 and 15, my lord.
Yes, you've shown that.
I have shown 14, and my juniors want me to place this. If I may place, my lord.
No, there is a Supreme Court judgment with regard
Yes,
to
my lord. Several judgments.
with regard to the specific point of the signature of the testator in the will. There is a specific judgment I am not having, I would say. If it has not been specifically denied at the time of cross-examination.
Absolutely, my lord.
It is not specifically denied with regard to the cross-examination.
Not only cross-examination, my lord, there is no specific denial in the written statement.
Wait, that's why. But
no denial at all.
Connected with the
my lord, may I place this paragraph 14 and 15, my lord? The perusal of the materials placed by the plaintiff, which are intended to be marked as bills, have already been mentioned by the plaintiff in the statement of account, but the original bills have not been placed on record by the plaintiff till date of filing of such application. It is further seen that during the entire trial, those documents have remained in exclusive possession of the plaintiff, but for reasons known to it, still the plaintiff has not placed these bills on record. My lord, the document comparison of which he intends to do was with him, and he had confronted the propounder while cross-examining it on the first day. In such circumstances, as rightly observed by the trial court, that at this belated stage, that too after conclusion of the evidence and final arguments, and after reserving the matter for pronouncement of judgment, we are of the view that the plaintiff cannot be permitted to file such applications to fill the lacuna in its pleadings and the evidence led by him. This is the point I want to highlight, my lord. As rightly observed by the trial court, there is no acceptable reason or cause which has been shown by the plaintiff as to why these documents were not placed on record by the plaintiff during the entire trial. Unfortunately, the High Court, taking note of the word "at any stage" occurring in Order 18, Rule 17, casually set aside the order of the trial court, allowed these applications and permitted the plaintiff to place on record certain bills, and also granted permission to recall PW1 to prove these bills. Though power under Section 151 can be exercised at if ends of justice so warrant, and to prevent abuse of process of the court, the court can exercise its discretion to permit reopening of evidence or recalling of witness for further examination or cross-examination after evidence led by the parties. In the light of the information as shown in the order of the trial court, namely those documents were very well available throughout the trial, we are of the view that even by exercise of Section 151 of the CPC, the plaintiff cannot be permitted. After change of various provisions by way of amendment in CPC, it is desirable that the recording of evidence should be continuous and followed by arguments and decisions thereon within a reasonable time. The court has repeatedly held that the courts should constantly endeavor to follow such a time schedule. If the same is not followed, the purpose of amending several provisions of the code would get defeated. In fact, applications for adjournment, or reopening and recalling are interim measures could be, as far as possible, avoided, and only in compelling and acceptable reasons those applications are to be considered. Here there is nil. We are satisfied that the plaintiff has filed these two applications before the trial court in order to overcome the lacuna in the pleadings and evidence. It is not the case of the plaintiff that it was not given adequate opportunity. That is why I placed those two orders. In fact, the material placed show that the plaintiff had filed both the application after more than sufficient opportunity has been granted to it to prove its case. During the entire trial, these documents have remained in exclusive possession of the plaintiff. Still, the plaintiff has not placed those bills on record. It further shows that final arguments were heard on number of times, and the judgments were reserved, and only thereafter, in order to improve its case, the plaintiff came forward with such an application to avoid final judgment against it. Such course is not permissible even with the aid of Section 151.
Thank you.
That is all.
That's all. Yes, sir.
Now the thing is this, in this context, I would like to place a judgment. It is passed by their lordships, the Honorable Justice R. Bhanumati and Honorable Justice Indira Banerjee. It is reported in 2018 AIR Supreme Court, page 5597. Page 5597. অনেকগুলো তো আছে। SCC তে আছে।
Law finder.
It is law finder.
2018 AIR Supreme Court 5596.
May I be able to pass the judgment? These appeals arise out of the judgment dated 30/6/2016 passed by the High Court of Odisha at Cuttack in CMP number 684 of 2016, in and by which the High Court allowed the appeal filed by the first respondent, thereby setting aside the order of the district judge passed under Order 6 Rule 10A CPC, thereby allowing the appellant's prayer for sending the signature of the will in question to handwriting expert for comparison with testator Natarabar Das's admitted signatures. The appellant herein filed CS number 2/34 of 2008-2003 seeking revocation of the probate granted in favor of the first respondent, that is Lakshminder Mahapatra, in probate miscase number 14 of 5 of 2000 of 1997. In the probate miscellaneous case, the will in question executed by Mahanta Natarabar Das was the subject matter in dispute, but according to the appellant plaintiff, the said Natarabar Das never executed any will as testator in favor of the first respondent Lakshminder Mahapatra. It is stated in the plaint that the late Mahanta Natarabar Das during his lifetime filed probate case number 19/13 of 1982 for probate of the will executed in his favor by one Jasuda Dasi, and in the said proceeding, the admitted signature of Mahanta Natarabar Das are said to be available in the petition, affidavit, vakalatnama, deposition, and the signature of Mahanta Natarabar Das appearing in those documents are required to be sent to the handwriting expert for comparison along with the will in question, and whether the signature in the will in question is that of the said Natarabar Das or not. On the other hand, the case of the first respondent is that the will was executed by the testator Mahanta Natarabar Das, and it was a genuine document. It was legally probated by the competent court. Since the appellant seeks revocation of the probate case number 14/5 of 1997 on the ground that the will of Natarabar Das is a fraudulent one, the crux of the issue is the genuineness of the will executed by the Natarabar Das in favor of the first respondent. The petition was filed by the appellant under Order 26 Rule 10 CPC to send the will in question to the handwriting expert, allegedly executed by Natarabar Das in favor of the first respondent and probated in probate miscase number 14/5 of 2000/1997 with the documents containing admitted signatures of Natarabar Das, which are available in the court in the earlier probate case number 19/13 of 1982. The application filed by the appellant under Order 26 Rule 10A earlier came to be allowed by District Judge Puri, void order dated 18/6/2013. The first respondent challenged the said order dated 18/6/2013 before the High Court in WP Civil number 14977 of 2013. By order dated 14/8/2014, the High Court set aside the order dated 18/6/2013 and directed the court below to consider the application filed under Order 26 Rule 10A at a later stage of the proceedings, that is after closure of the evidence from both sides. The High Court also directed disposal of the trial proceedings in CS number 2/34 of 2008/2003 at an early date. The trial commenced and parties adduced their evidence. At that stage, the district judge filed order dated 15/3/2016 allowed the application filed by the appellants under Order 26 Rule 10A CPC, directing that the will dated 12/3/1989 be sent to handwriting expert for comparison with the admitted signatures of Natarabar Das, which are available in the petition, affidavit, vakalatnama, and deposition in probate case number 19/13 of 1982. This order has been set aside by the High Court by the impugned judgment. To resist the appeal and the prayer of the appellant to send the will dated 12/3/1989.
Not required, sir, not to read. There are 3 points.
Yes.
In this case, initially they filed an application under 26 Rule 10.
Yes.
That was rejected. Went to the challenging that. The court has stated that it may be considered subsequently.
Yes.
After the evidence is over.
Yes.
After the evidence is over, it was allowed.
Yes.
It was taken into consideration. So the limitation point was there. Now, second point with regard to they have taken that they have taken a specific ground in the written statement. The will is not genuine.
Yes.
The court has considered, yes, they have taken the ground in the written statement. The will is not genuine. That's why it has to be sent to the. This is the
Yes.
first observation. But
Mine
the-
is exactly
where-
the same.
Yes, where is your averments in the written statement that the will is not genuine?
Will is not genuine.
And the,
The-
fraudulently it was affirmed
yes,
for-
yes,
it
yes.
was executed fraudulently.
Yes. In my affidavit is sort of the caveat
Correct,
also
correct.
from the very beginning. From very beginning, I'm stating that it is a forged will.
Yes.
And while adducing evidence, the defendant specifically stated that the testator has not executed any such kind of will. Okay. First, I'm placing my affidavit in support of the caveat.
Yes, I have. Yes, paragraph 9.
Paragraph 9. Yes, yes, yes. The signatures as well as the initials.
Now kindly come to the cross examination. Have you taken this? Have you taken this?
Absolutely false and forged.
In the cross examination, you have taken that
Yes,
plea?
yes, yes, yes. In cross examination. আচ্ছা এই propositionটা propositionটা ওই ফাইলটা আছে দেখো তো application. Over both of the two attesting witnesses, they have not, none of them has placed any address while putting
No,
their
where is the question that the signature is forged one?
Yes, yes, yes.
That is the question in the cross examination.
আমাদের ক্লায়েন্টের ক্রস এক্সামিনেশন গুলো কোথায় দাদা এই আমাদের এখানেই আছে We'll just come to paragraph number 12 of my application. Moreover, in answer to question number 47, the defendant herein has summarily denied the existence of the will in question because, according to her, the testator herein, being her father-in-law, had rest assured her that he had not executed any will in his lifetime.
Yes, next.
It is in answer to question number 47.
Yes.
Moreover, apart from that, the defendant herein further informed the court that apart from the two properties as mentioned in the purported will, the testator had two more immovable properties which were self-acquired properties of the testator himself. These are the properties situated at 34/2A Baliganj Circular Road, PS Gorihat, Kolkata 70019, and another one is at Bolpur Shantiniketan in the district of Birbhum, West Bengal. In reply to question number 30 and 50, the defendant adduced evidence in this regard. Now the thing is this: none of these properties have been mentioned in the will in question, especially the property in Baliganj, 34/2A Baliganj Circular Road, where the testator used to reside, and the propounded adduced evidence over there only in 32/2A. That property has not been mentioned in the will, but in reply, she has adduced evidence that it is defendant adduced evidence in this regard that it is his property, but she has denied to show any deed regarding this. So it is quite clear that the my client has totally denied the existence of the will. According to her, every entire will is forged. Moreover, if one can see in open eyes, he will understand that two different signatures are totally different.
Yes.
Hmm. 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 If the testator has not executed any will in his lifetime, then definitely the signature has to be a forged one.
Yes. Then anything further? Any further?
Yes, may I hand over the copy of the judgment, what I have shown your lordship?
Yes, I'm having.
Oh, sure, sure. So I'm just praying before lordship that for ends of justice, a purported will should not be allowed to be probated. It is 100% forged will. Apart from the admitted documents, what we have mentioned over here, his lordship's signature is hundreds of signatures of his lordship is available in this court. If your lordship directs the office to produce his lordship's signature, hundreds of his lordship's signatures will be produced in front of your lordship. So, considering all this aspect, let the final judgment be passed. It is my most humble and respectful submissions that in no circumstances a forged will should be allowed to be probated. Beyond going off all the technicalities, please do consider this aspect of the case. These are all technicalities, whatever my right friend has submitted.
Thank you.
My lord, I don't want to make it long drawn. The only thing my learned friend had put these questions that these regarding two other properties which he has mentioned, and the propounder has said that those two properties belong to her. 96, 97, 97, 98.
Especially property in Baligon Circle area where
She said those properties belong to her.
Yes.
Let him produce the deed.
Why should he? This is not a civil suit.
That's all.
Yes.
Hearing concluded. PM. दो बजे fix है.
Well, before Lordship rises, if Lordship permits me, my lord, may I make a humble request? Item 10, I was engaged elsewhere. I apologize, my lord. Lordship has made it in a monthly list. Kindly keep it in, not today, my lord. I will argue tomorrow, my lord.
No, there is no time. That way fix in the.
No, my lord, kindly do not, my lord. I was engaged elsewhere, my lord.
Not
I apologize, my lord. I
If
apologize.
you have not come in the time, no, how? Because tomorrow already my time diary is fixed.
No, my only, my lord, what I say, my lord, kindly keep it not today, my lord. I will try my luck tomorrow or day after, my lord. Kindly do not, my lord. Lordship has said it is a monthly of December.
Adjusting, but now these 2 days it is very difficult.
No, Lordship has said
So
monthly list of
injunction is
December.
also
my lord.
coming, the
Lordship has
interim orders
already
also-
heard the matter. I was about to give a reply, man. A short reply. Very well, Lordship.
Judgment reserved.
Yes.
I am not taking change from the for defendant.
Earlier,
Change from the erstwhile law hearing.
earlier someone else was appearing, now a new set of files. Lord, on the last occasion, your lordship remembers, we had filed an affidavit of admission denial that was not in proper form. So I'm filing my admission denial, my lord, and the judge's brief of document upon service to my learned friend.
No, it is not served.
Upon serving to my learned.
Okay. Yes. So time has elapsed, 2 weeks back. Or similar directed to file within 4 weeks. On 5th of August.
Yes, continue.
Yes,
Mr. Present.
Yes, ma'am, my witness. Hello,
You repeat after. I solemnly affirm that in whatever I will depose by way of evidence in this suit I shall speak the truth and no part of it shall be false and I shall not
Admission and
denial conceal anything.
conceal anything.
What is your
Admission
name, sir?
denial.
Mukund
It's already
Mani.
filed, sir.
Mukund?
Filing of right.
MU.
No. Admission denial was already filed by them.
I'm told it's not.
Kindly seize the records. On the
MEM.
last occasion, it was filed by them.
I have
MI.
the brief. Vimani.
May I see
No,
the
no.
admission denial that you are
Govind
filing?
Das
Counsel
Mumani.
for the print parties press for extension of time to file affidavit of addition and denial.
No, blood, but
Das.
very well. ठीक है. Very well.
फाइल है नहीं है ना? Yes, continues.
Vimani. Age.
छेड़ दो बेटा.
Nine.
Occupation.
Business.
Address. Residence.
4 Southern Avenue. Calcutta 26.
Computer.
Witness is shown an original document. तो दिया है evidence. Please turn to page 17 of this document. Sorry. No. Witness is shown an original document. What is this document?
This is evidence, affidavit in evidence.
Please turn to page 17 of this document and tell my lord who has affirmed this affidavit in evidence.
I have affirmed this.
Please tell my lord the date on which this affidavit was affirmed.
Was affirmed on 22nd of September.
Are you in a position to tell my lord before whom has it been affirmed?
Before the oath commissioner.
Yes. Mr. Witness, what do you say regarding the contents of this affidavit?
The contents are true and correct.
Mr. Witness, will you be in a position to tell my lord on what basis have you deposed that the contents are true and correct?
The contents, I am actually involved in the transaction and correspondence of all the
Actually involved in the transaction and correspondence of the
all transaction involved in this.
all transactions and correspondence in this suit regarding this.
Shown original document. Please tell my lord what is this document?
This is affidavit under section 65B.
Please come to page 3 of this affidavit and tell my lord who has affirmed this affidavit.
Myself, I have affirmed this affidavit.
Please tell the date on which this affidavit has been affirmed.
22nd of September.
25th September.
2025.
Mr. Witness, please tell my lord, before whom has this affidavit in under section 65 be affirmed?
For the oath commissioner.
But may these two affidavits be tendered. Shown an original document, copy of which is appearing as Annexure A to the affidavit in evidence. Please tell my lord, what is this document?
This is an authorization letter received from the plaintiff.
Received from?
From the plaintiff, sir.
Please tell my lord, what is your connection with the plaintiff?
Plaintiff is my father.
Can you please tell my lord the date on which this authorization has been given?
This was given on the 1st of September 2025.
Mr. Witness, under this authorization letter, what has been authorized to you?
I was authorized to act on behalf of the proprietorship firm to file affidavits and do all necessary works in the interest of the proceedings related to Honorable High Court. Calcutta.
Who had थोड़ा माइक में बोलिए जोर से माइक का होना चाहिए हाँ मैं काছে আসবো who has signed this authorization letter?
The plaintiff has signed the authorization letter.
Can you please encircle the signature of the plaintiff? In red.
With the red pencil, huh?
The witness encircles.
Yes.
How was this authorization handed over to you?
The plaintiff has signed the authorization in front of me and handed over to me.
But may this document be marked as Exhibit A, the original?
Exhibit A.
Exhibit A. Mr. Witness, please tell my lord, what is the connection of the plaintiff with the defendant?
Defendant is one of the retailers to whom we supply. The plaintiff supplies.
Defendant is one of the retailers.
To whom?
To whom electronic goods have been supplied.
Yes. Electronics goods have been supplied.
Supplied, yes.
By
whom?
By the plaintiff, sir.
Yes. In what capacity were the goods supplied by the plaintiff to the defendant?
Capacity.
Uh,
Plaintiff is a distributor of Samsung India Private Limited. Samsung India Private Limited forms distributors of particular geography and authorizes to sell materials to all the retailers in that geography.
in that
Geography, he says.
geographical area.
Geographical area.
Mr. Witness, please explain and or identify the term retailer of the plaintiff as deposed by you in your earlier answer.
Retail.
Meaning of retailer.
Meaning of retailer here is all the shop owners, shopkeepers who selling electronics product in a particular area assigned by the company. Those retailers are termed as retailers or dealers.
please tell my lord, how was the products supplied by the plaintiff to the defendant?
Products were supplied by way of invoices raised on by the plaintiff to the defendant on the defendant.
What was the terms of supply during the currency of the contract between the plaintiff and the defendant?
The terms were on receipt of goods. Payment will be made within 15 days after the goods have been received by the defendant. Otherwise, 18% interest will be charged.
Shown originals of the documents, copies of which are appearing at pages 16 to 79 of the judge's brief. Mr. Witness, kindly have a look at the documents handed over to you and tell my lord, what are these documents? 179, 16 to 179.
179.
16 to 179. 79 बोले दिए थे 16 to 179.
Yes. What are these documents?
My lord, these are invoices which have been raised by the plaintiff on the defendant for supply of materials.
Yes. Please tell my lord, who has issued these invoices?
Plaintiff has issued this. Under my I have issued these invoices.
Please tell my lord, how are these invoices issued and maintained?
These invoices are maintained in an accounting package known as Tally ERP software.
Tally
ERP software.
Since you have deposed in your earlier answers that these invoices were raised upon the defendant, are you in a position to tell whether these invoices were served upon the defendant?
These invoices were served. It is quite evident. There are stamp and signature of the defendant on the invoices.
Mr. Witness, will your answer be the same for the documents from 16 to 179 of the judge's brief of document?
Yes, sir.
Please have a look at one of the invoices and kindly apprise this honorable court the basis of arriving at the price mentioned in the invoice.
Samsung India Private Limited bills at a particular price.
Bills at a particular price.
At a particular price for different products at different point of time. Similarly, plaintiff bills to their retailers at a particular price basis on the quantum of order received from the retailers or dealers, whatever you name it.
Retailers or dealers? Can you please elaborate? Can you please tell my lord why have you deposed inverted commas Samsung in your earlier answer?
It is because there are three parties to this. Relation between Samsung is with the plaintiff only, and my relation is with both the defendant as well as Samsung.
Oh yeah.
Yes.
Mr. Witness, please tell my lord, since you have deposed the relationship of the plaintiff with the Samsung. Please tell my lord how, what is the relationship of Samsung with the defendant?
There is no relation between Samsung and the defendant.
On what basis do you depose that?
Because Samsung India bills the plaintiff, issues invoices on plaintiff's name, trade name. And in turn, we, as I earlier told, that company gives us a geography to work, geographical area to work, wherein there are maybe 200, 300 retailers. So we in turn distributes Samsung products to these retailers.
So what would your answer be if I ask? No, no, then please tell my lord how the defendant is to obtain products of Samsung.
Defendant verbally or through emails issues orders to us, to the plaintiff, and in turn we used to bill and send the materials.
Mr. Witness, so will I be correct in suggesting that in case the defendant requires products, it has to mandatorily contact the plaintiff?
Yes.
Please come back to the invoices, original invoices, and please tell my lord who has signed this invoice on behalf of the plaintiff.
This is done by the godown keeper, Mr. Snehashish Mandal.
Are you in a position to identify the signature of Mr. Mandal as deposed by you?
Yes, sir.
Please encircle the same. Mr. Witness, as deposed by you, do you find, as deposed by you in your earlier answers, that the defendants have received the invoice? Do you find a receipt in the invoices shown to you? Original invoices shown to you?
Yes.
Are you in a position to identify that? Please encircle that. Yes, encircles the stamp and seal. Stamp and seal in the invoice in red ink. Mr. Witness, kindly have a look at the invoice and tell my lord what was the mode of transportation of each of the goods specified in each invoice?
Goods used to be dispatched through Tata Ace vehicle.
Dispatched through Tata
Ace.
capital ACE.
What do you mean to say the Tata Ace?
Tata Ace is a vehicle, sir, manufactured by the Tata Group.
The vehicle manufactured by the Tata Group. Since you have deposed the name of the vehicle, does the plaintiff use to provide that information in the invoice?
Yes, it has been provided. There is a column dispatched through.
There is a column in the invoice mentioned as
dispatched through, wherein there is a vehicle number.
Yes. Can you also tell my lord from which point to which point were these goods delivered through Tata Ace having through vehicles having identification number under the column dispatched through?
Period.
No.
Place of transportation from your godown to the which place of transportation?
Destinations are mentioned in the invoice on the left hand side. There were probably 3 destinations, one at Patuli.
One is at Patuli.
One at Behala. And one at Park Street.
Park Street.
Will your answer still be the same for all the documents of which originals have been shown to you?
Yes, sir.
Full stop. As deposed by you in your earlier answers, the defendant was to make payment within 15 days. Was this practice adopted in the invoices, in the originals of the invoices shown to you?
No, never.
No, full stop, never. One suggestion, my witness has identified the receipt and the sign, but it's only on one invoice. But there are receipt and sign in every
All
invoice.
will be exhibited at collectively.
Then not collectively, it may be
Through court.
Through court.
Collectively exhibit. Exhibit B collectively. Page 79 to page 16 to
16 to 179.
179. Exhibit B collectively. Through court. So as per your deposition, you are the main dealer. Samsung India Limited providing the materials to you,
Yes, sir.
electronic goods to you,
Sir.
and you supply to the local market as per their convenience,
Sir,
as per
correct.
their demand.
Correct.
Mr. Witness, identify address as my lord, not sir.
Sorry.
Shown page 180 of the judge's brief of document. Volume 2. ওইটা কেটে দিন তো আমি আবার জিজ্ঞেস করছি ওইটা কেটে দিন shown a document copy of which is appearing at page 180 of the judge's brief of document. Use the printout of the ledger. There's no question of origin.
So, my lord.
Wait.
Question.
Please tell my lord, what is this document?
This is the ledger account maintained by the plaintiff of the defendant.
Please tell my lord, what is the mechanism in which this ledger is maintained?
Again, this is maintained in our accounting package, Tally ERP software.
ERP software. Who maintains the ledger in the Tally ERP software?
Our accountant maintains it under my supervision.
Mr. Witness, do you have access to that Tally ERP software?
Yes, sir.
Can you please tell my lord, for which period till which period is this ledger annexed to the judge's brief of document?
The period is starting from 1st April 2017 till 3rd Feb 2023.
What is the net effect of this ledger which has been shown to you?
The net effect is plaintiff is yet to receive 18,08,294 rupees
294
as principal amount.
What is the last date of entry as per this ledger?
November 2021.
Mr. Witness, on what basis have you just deposed that the plaintiff is to receive a sum of rupees 18,08,294 from the defendant?
Going through the ledger, you can very well ascertain that invoice ledger, one can ascertain that all the bills issued and the payments received, along with all the respective credit notes, have been given, and the final figure which is yet to be received is 18,08,294.
Full stop. Mr. Witness, why did you mention the term, inverted commas, credit notes in your earlier answer?
Samsung India Private Limited, during the course of business, issues or provides us discounts for the promotion and development of business in the geographical area, which we use it to achieve our monthly targets set by the company, and as per the order received from the retailers, we pass on certain amount from it. These are known as the credit notes.
Mr. Witness.
So,
Yes.
as per your statement, once the bill invoice has been raised, but whatever the benefit you are getting from the company, so you are giving that benefit to the retailers.
Yes, my lord, but it depends on the quantum of business.
Correct. What you are getting, so you are giving the
passing
out to the retailers for the promotion of your the Samsung products.
Yes, my lord.
Please tell my lord on what basis were discounts received by you from Samsung and passed on to the defendant?
Discounts, basis of discounts are different for different products, for different periods. So there is no particular basis. Depends from time to time, and we also in turn issues credit notes on that basis.
Mr. Witness, please tell my lord, in this instant case, has the plaintiff passed on the benefits obliques discounts to the defendants for the relevant products ordered by the defendant?
Yes, it is very evident from the invoices itself. There is a column in the invoice, discount. Major part of discount is issued on the invoices itself. And if there is some other supplementary discounts which we received in the course of business, we pass on by way of credit notes.
Can you please also tell my lord on what basis did the plaintiff used to get discount from Samsung Electronics India Private Limited?
Samsung Electronics India Private Limited issues circulars, discount circulars, and those circulars were used to be mailed to us on our mail ID. That was the basis of.
Mr. Witness, also kindly depose before this court to whom was the circular issued by Samsung Electronics India Limited issued, and for whose benefit?
Circular of Samsung was always issued in our name, in the name of the plaintiff, that is Sriji Electronics. It is very evident. If you will see a circular, our name is mentioned on it.
If one sees this,
and also please tell my lord on what basis was each circular passed on to the defendant?
Circular was not meant for any retailer or dealer directly. It was for the promotion of their products and used to achieve the target of the company set on monthly basis. So accordingly, on the size of orders, we used to pass on the discounts.
Kindly come back to the document and tell my lord who has taken printout of this document?
Myself.
As deposed by you in your earlier answer, this document is maintained in Tally ERP software. Maintained in Tally ERP software. Will I be correct in saying that? Now, please tell my lord that the printout of this document is the same as is maintained in Tally ERP software.
Definitely, sir. Yes.
But may this document be marked as Exhibit C. Judges brief page volume. Shown page 223 to 236 of the judge's brief of document, and kindly tell my lord what are these documents.
These are emails issued by the plaintiff for recovery of the outstanding sum of rupees pending as on that date, whenever the email has been issued.
Mr. Witness, please identify the email of the plaintiff and the defendant as deposed by you in your earlier answer.
This is email dated 23rd November 2017 at 6:03 p.m.
No, email name, email ID.
Email ID. Email ID is Mukund Memani 1 @gmail.com.
And of the defendant.
And then HHPVT PVTD @gmail.com. Another HHPVLTD @gmail.com. AC dot LTD. The dates to be
Please tell my lord why were these emails issued by the plaintiff?
Already
For the-
stated.
Already stated. Please tell my lord what was sought by way of issuance of these emails by the plaintiff.
emails were marked so that we can, whatever the outstanding is due more than 15 days, which was agreed at the time of starting of the business. Outstanding, whatever was more than 15 days, we were seeking the payment of those.
What do you say regarding the contents of these emails?
If you go through the emails, it is very well clear that we have attached working also.
Question is, what about the contents?
Contents are true and correct, sir.
Who has, Mr. Mimani, who has taken the printout of these emails?
I have taken out the printouts.
Since you have taken the printout of these emails, can you tell my lord, are the printouts of these emails same as is maintained through the online server?
Yes, sir.
But may these emails be marked as Exhibit D collectively?
C.
D, my lord, D. D. Acha. Tone page 237 to 241 of the judge's brief of document. Kindly tell my lord, what are these documents?
Exhibit A there.
Authorization.
This was an instance when we have met the defendant once and then mailed about our outstanding to him, to the defendant, on outstanding values due for payment.
Kindly refer the email dated January 15, 2022 at page 237 and tell my lord what has the defendant stated in the email.
Defendant here is asking Samsung to give discounts to them as committed. Defendant here has mentioned that Samsung will issue them credit notes, wherein on the same date wherein if we go to page number 238, one of the Samsung employee, Mr. Ravinder Kumar of Samsung India Private Limited, has stated clearly that defendant is only related to the plaintiff in terms of business. They are nowhere involved and they have never committed anything in by way of discounts to them directly.
Is this your evidence that Mr. Witness? Mr. Witness, please turn to page 239 of the judge's brief of document. Is this the email you have been referring to?
Yes, I was referring to this email.
Can you also please identify who Rabinder Kaur is?
Ravinder Kumar is
Ravinder Kumar, I'm sorry, Ravinder.
Is an employee of Samsung India Private Limited.
What has Mr. Ravinder Kumar in his email at page 239 stated?
He has clearly stated that he has never committed to the defendant and he has no relation whatsoever with the defendant directly. Samsung, and he clearly states that Samsung India has only one relation in terms of business, that is the plaintiff.
Who has taken the printouts of these documents at pages 237 to 241 of the judge's brief of document?
I have taken out.
How have you received these documents at page 239 to 241?
Through emails.
Are you in a position to tell my lord that the printouts of the emails are the same as is maintained online? Lord, may this document be marked as Exhibit E.
Exhibit क्या है?
E.
E collected.
Lord, may I make a request? I'm being led by Mr. Ghosh. If I go in this manner, I'll conclude. Lord, I'll get in a fix. May I do it on the next day?
Why?
Lord, if I proceed, I'll conclude. Next are the letters, so it will take 5 minutes. I'm being led by Mr. Ghosh.
No problem. No, Ghosh name will be there.
He is engaged in code 40, Lord.
No problem. You're doing well.
No.
No necessity of Mr. Ghosh.
Your
You're
Lordship.
doing well.
Shown shown an original document, copies of which are appearing at pages 242 to 249 of the judge's brief of document. Please tell my lord, what is this document?
This was the letter issued by our advocate on the defendant when we have failed to get our payments back.
Who had instructed the learned advocate to issue the notice dated July 30, 2022?
My lord,
July 30, 2022.
my lord, plaintiff has issued the direction along with myself.
Is this your evidence that you and the plaintiff had apprised the learned advocate of the facts mentioned in this letter?
Yes.
Can you please tell my lord what was sought for and or intimated to the defendant by way of this letter?
The dues which were pending for long was sought for to be paid immediately.
Kindly identify the sum claimed by you, claimed by the plaintiff in the letter dated July 30, 2021.
Sum is 18,08,294 along with 18% interest.
What do you say regarding the contents of this letter dated July 30, 2022?
Is that true and correct?
Are you in a position to tell my lord whether this notice was, please tell my lord, how was this notice served upon the defendant?
By speed post, India Post.
Can you also apprise this honorable court as to whether the defendant has received this notice or not?
We have the receipt copies of India Post, which clearly shows that
Track report.
Track
Consignment receipt.
consignment receipt.
Next question. Correct. Mark why nahi hua? Mark nahi hua.
Not yet marked.
Not yet mark. After being in, please tell my lord the date on which the defendant received this notice.
Second of August.
Are you in a position to tell my lord whether this notice was replied to by the defendant?
No, it was not replied, sir.
Lord, may the original letter and the track receipt be marked as
Exhibit
collectively.
F
collectively. Yes, next.
Next. Shown letter dated. Shown an original document, copy of which is appearing at page 250 to 255 of the judge's brief of document. Please tell my lord, what is this document?
Upon non-receipt of any reply from the defendant, a second letter was issued seeking our outstanding payment.
Please tell my lord, what was the sum claimed in this letter?
18,08,294 along with 18% interest.
Are you in, who had instructed the learned advocate to issue this letter?
Plaintiff.
Are you in a position to tell my lord whether this notice was... Question again. How was this notice served upon the defendant?
By speed post.
Are you in a position to tell my lord whether this notice was received by the defendant?
Yes, we have the track consignment receipt.
Kindly apprise this honorable court of the date on which this notice was received by the defendant.
On the 6th of September 2022.
Lord, may the original letter and the delivery receipts be marked.
Exhibit G collecting.
shown page 256-257 of the judge's brief of document. Please tell my lord, what is this document?
पेज नंबर देख के दो
256 to 257.
After the two notices which we issued, we received an undated letter from the defendant.
Can you please tell my lord, what has the defendant stated in this letter?
Defendant here states that they denies all the dispute and claims and allege that no money is due to them.
How have you received this letter?
To speed post. That's from to the advocate.
Where is the original of this letter, which was received by the plaintiff?
It is with the advocate. It is with you. With my advocate, sorry.
Why has the plaintiff disclosed a copy of the letter instead of the original?
The original is with my advocate.
Mr. Tiwari, you are denying this letter? It is your letter.
No. Then it may be marked as exhibit. Pages 256 and 257 collectively.
Exhibit H.
Shown an original document, copy of which is appearing at pages 258 to 266 of the judge's brief of document. Please tell my lord, what is this document?
This is the third and final letter which my advocate has issued demanding immediate payment.
Can you please tell my lord, what was the sum claimed in this letter?
Sum is 18,08,294 along with 18% interest.
Can you please tell my lord, under whose instructions was this letter issued?
Under the instruction of plaintiff along with myself.
Can you also tell my lord, how was this notice served upon the defendant?
By speed post, it has been served.
Are you in a position to tell my lord whether this notice has been received by the defendant or not?
Yes, according to the track consignment receipt, it has been received by them on 2nd of December 2022.
And what do you say regarding the contents of this letter?
It is true and correct.
Yes. And please tell my lord, has the defendant replied to this letter after being in receipt?
No, they have not replied.
Lord, may the notice be marked along with the track receipt. Lord, the next exhibits are, Lord, one Supreme Court judgment. That time clarity was not there, so I am not annexing it. And next is the mediation report. That also they have admitted, I am not annexing it. And Lord, my chief stands closed, but your lordship formally do not close it. Otherwise, I am being led by a leader. This will create an issue.
But you get it ready on the next date.
Yes. We
after vacation.
Yes, after vacation.
After vacation. Ah.
Your lordship may kindly then fixes a next date.
The Plaintiff is present and has filed judge's brief of document, affidavit of evidence, and affidavit of denial and
Admission denial.
and denial of the documents. Let the same be kept with the record. The defendant has also filed the affidavit of admission and denial of the document. Let the same be kept. Let the same also be kept with the record. During the examination of the plaintiff witness, documents were marked as exhibit A to I.
A to I.
A to I. Police counsel for the plaintiff. As per the prayer made by the counsel for the plaintiff, chief is deferred. Let the matter appear on 23rd December at 3 p.m. for further examination, chief, and cross examination.
Yes. Great from Lord.
Last date for the
Xmas holiday. 23rd December at
3 p.m. 3
3
p.m.
p.m. Great. I'm great.
Okay. 12:30. 12:30.
12:30. 12:30. Yes. Great from Lord. मेरे लिए आप लेकिन
Number 15 is my application. Sir, my lord, in this matter, there was another application which your lordship had disposed of few days back. My lord, the commercial dispute point which your lordship had negated and held that the suit is a commercial suit. My lord, GF4 is my application for further injunctions on various other properties of the defendants. My lord, they had filed an affidavit where there were various discrepancies. They had sought to contend that the value of the property which they are now offering is more than the claim made in the suit. So, my lord, there is the injunction on the bank accounts made. Yes, Karnani construction, that matter. Now, my lord, I'm told they have preferred an appeal.
Against this?
Against the previous order, where your lordship had granted an order of injunction. That appeal is.
That one.
Yes, that is. Nothing, they have not moved it and it has not been listed as well. But I don't know what to do now.
Now this court will be blank. All will be in the appeal.
Yes, everything will be in the appeal. But my lord, may I only.
Court will sit idle.
But you kindly make it one.
Because again, this order will also be challenged.
Maybe it's not an appealable order. Supreme Court, yes. But you kindly give me one moment. তাহলে একটা করি ব্যাংক অ্যাকাউন্টের উপর করে তারপর ওটা ওই আওরা এক্সপায়ার করে গেছে but may I indicate one thing that firstly my lord, the defendants were supposed to file a supplementary affidavit indicating the present market value of the property which they offered, that they have not furnished. But insofar as the interim order which your lordship had passed earlier, but which is of 31st July 2025.
21st July?
Yes, 31st July 2025.
Yes.
Paragraph 7, if your lordship takes at page 3.
Defendants are free to operate the bank account subject to keeping aside amount number 94.
This your lordship will confirm and then dispose of this application, nothing else.
No, then subsequently Mr. Lakmani will come.
Lordship. One submission, your lordship. My senior is on the way, your lordship, immediately. You could grant a short passover.
Passover.
Grateful, your lordship.
Item number 17. But will your lordship keep it tomorrow then? Passed over?
Not today.
Okay.
Not today. Yes.
Lord, item 17, I'm being led by Mr. Das, my lord. I was placing my application on the last occasion, lordship.
You are appearing for whom?
Petitioner, my lord.
Who is for the defendant?
My lord, the defendant is not appearing, my lord. We had
appearing.
Not appearing, my lord.
What
Lord,
application you filed?
my lord, DA2 was a application for.
What is the 2?
my lord, for judgment about admission, my lord, for a sum of rupees 32,32,000 odd. My lord, I had handed over a note on the last occasion, my lord, written note, wherefrom it is evident that the defendant, in its opposition to my GA1, has admitted that said amount is due and payable to me. My lord, if my lord takes GA2 once, volume 1, my lord, kindly takes page number 8.
Page number?
8.
8.
Volume 1.
Yes.
The judgment and decree on admission for a sum of rupees 30 lakhs 32,000 as pleaded in paragraph 18. Now, my lord, if I am allowed to show the opposition to GA1, my lord, kindly takes volume 2, page 166 of GA2. My lord, I have annexed the opposition, my lord, at page 166. My lord, top of page 163 will find that I am reading from page 162, paragraph 16. That with regard to the statement made in paragraph 23, I deny and dispute the allegation put forward, and I submit that there is no warrant against me pending before any court of law, and as such, I have no intention to commit cheat or fraud upon the petitioner, and herein and shall definitely refund the outstanding sum of rupees 30,32,055 upon release of the custom security deposit, which he is entitled to. Well, with respect to this admission, my lord, I have preferred my application. I have also handed over a note on the last occasion, my lord, if my lord will find it. In that note, my lord, I have also relied upon a judgment of the Honorable Supreme Court, my lord. I have handed over a copy, my lord. That is annexed to the application, my lord.
Which paragraph?
My lord, just a minute. Paragraph 13, my lord.
GA1 is disposed of?
No, my judgment is pending, my lord. They had filed their opposition, thereafter they've stopped appearing, my lord.
Yes, then?
My lord, I'm seeking an order with respect to GA2, my lord. But in that event, my lord will keep it after the vacation because Mr. Das is not here. Mr. Das is leading me, my lord. He's not here. If my lord intends to seek any clarification, my lord can keep it after the vacation.
What is your total claim in the plaint?
My total claim is around 80 lakh rupees, my lord.
80 lakh. And you pay for the part 30.
30 lakhs 32,055.
One crore 52 lakh. Paragraph 15. So your principal amount is 80 lakh.
80 lakh.
And they have admitted 30 lakh.
30 lakhs 32,000. They have admitted.
Plaintiff has filed an application being GA-Com 2 of 2025, praying for judgment upon admission for a sum of rupees 30,32,055 on the basis of the admission made by the defendant in the affidavit in opposition in connection with GA1 of GA1
GA1 my lord.
GA1 of 2025,
4.
2024 in paragraph 16, wherein the defendant has stated that the outstanding due of rupees 30,32,055 upon release of the custom security deposit which is entitled to. क्या बोला? Admitted that 16, not 6.
16.
No. She stated that inward comma, I have no intention to commit cheat or fraud upon the petitioner herein and shall definitely refund the outstanding overdraft. Full stop. Counsel for the plaintiff submits that though the claim of the plaintiff in the print is an amount of rupees, where is the print? Is an amount of rupees 1 crore 52 lakhs. That is principal amount of rupees 80 lakhs and the remaining amount of 72 lakhs is the interest at the rate of 18% per annum on and from 22nd April 2019 till 24 Counsel for the plaintiff submitted as the defendant on affidavit has admitted the part claim of the plaintiff for an amount of rupees 30
32 lakhs 4,129.
page
My lord,
162 where 30 comma 32 comma 1055 and as such the plaintiff is entitled to get judgment and judgment upon admission for the said claim admitted by the defendant. None appears on it is fine from the record for the last several dates, none appears on behalf of the defendant. The plaintiff has paid for a decree for a sum of rupees 80 lakhs along with the interest at the rate of 18% per annum. In total, rupees 1 crore 52 lakhs. The plaintiff had filed an application being GACOM 2 of 2024, praying for interim order. The defendant is contesting the said application by filing affidavit in opposition. In the affidavit in opposition of GACOM 1 of 2024, at paragraph 16, in reply to the paragraph 23 of GA1 of 2025, GACOM 1 of 2024, the defendant has stated as follows. So, 162, paragraph 16. In the said paragraph, the defendant has categorically admitted that the defendant will refund the amount of rupees 30,32,055 upon release of the custom security deposit. Where is that custom security order? Custom security deposit. Custom security. Considering the above,
the order starts at 102, the relevant page.
102.
102, it's 102, volume 1 of GA2, my lord. And the relevant
appeal is disposed of?
No appeal has been.
Where is that? Where is the order?
The order 102 up to 130, the relevant portion is 130.
The plaintiff has relied upon the order of the custom appeal.
That is
order passed in the custom appeal. Dated
12th October 2023.
Dated 12th October 2023. Wherein
page 138.
Wherein the appellate authority has dismissed the two appeals. And hold that the claim of the defendant is to be refunded. Considering the above, this could find that the defendant has admitted the part claim of the plaintiff to the tune of rupees 30,32 jitna hai na 30,32,055. Thus, the plaintiff is entitled to get the decree upon and get the judgment upon admission for its sum of rupees 30, 32, 055, 055. The defendant is directed to pay the said amount to the plaintiff. With regard to the remaining claim of the plaintiff is relegated to the trial. GACOM 2 of 2025 is disposed.
My lord, in respect of GACOM 1 as well, my lord, the plaintiff, the defendant is not appearing or disputing. My lord, the injunction may be made absolute.
Come on the next. Interim order is there, no?
There is interim order, my lord.
Till?
It is there till November, end of November. My lord, there was also a direction for depositing the security with the registrar. We have obtained the certificate. It has not been deposited. It is still lying with Standard Chartered Bank, my lord.
Yes, next.
Much of
Item number 18, my lord.
My lord, item number 15 and 16, we both prayed for not today. Just
Not today.
my lord, just a small indulgence. My lord, this matter can be kept after vacation because we have preferred an appeal. If that
That interim order may be extended.
15 se unka.
Yes.
15, 16 na madam. As per the prayer made by the counsel for the defendant, case is adjourned. Let the matter appear on 23rd November, 19th November 2025.
The
interim order is extended till 19th November 2025 or until further order, whichever is.
Great.
Yes, call the fixed matter.
Item number 4 of the non-commercial.
I appear for the plaintiff.
May I seek for an indulgence before my lord calls the fixed matter, my lord?
Yes, call.
My lord, I appear for the plaintiff. My lord, the defendant's witness was being cross-examined. Lord, today, my lord, I believe they'll continue. Was being examined. I'm sorry. Was it being examined in chief? Cross is yet to commence, my lord.
No. Questions? What is he waiting for? 18?
He will take dictation. He will take dictation. Our is
Prem Gyani.
Prem?
Gyani.
Prem Gyani.
He's under oath already. Sir, with your lordship, please.
GIANI.
Shown question 3. I'm sorry, question 4. Of the examination of your examination in chief. Sir, you have identified the written statement which has been filed. What do you have to say about the contents thereof?
The incorrect. My statement.
Read. Superb.
Go through the question number 3 and question and answer. 4. 4.
It's happened to me before. Not the first time. See question 4.
Yes.
The question is you've identified the written statement.
Yes.
The question is what do you have to say about the contents of the written statement?
This statement has been filed by Mr. Chirag Tekchandani. Chirag Tekchandani. Who was authorized by the firm, by Calcutta Carpet Store, by the defendant to handle all affidavits proceedings for them. And our advocates made out the statement on our behalf
made out statement
on our behalf,
which were checked
which were checked
and filed by Chirag.
What did you check and discover? What did you and Chirag Tikchandani check and discover?
We checked that we were the owners of the premises.
I am asking you. Now, you have deposed right now that you checked the contents of the written, that you and Chirag checked the contents of the written statement.
Yes.
I am now asking you that after checking, what is your reaction to the statements contained in your written statement?
That these were true, whatever has been submitted. Yes.
What shown?
those were true which we have submitted.
Yes.
Shown paragraph question 7 of your examination in chief. You have deposed that there is an error. Can you point out the error now?
Yes.
Please do so.
Huh.
May I show him a copy of the written,
Show the
your
written-
original written statement?
So the written statement.
The fourth para was mentioned. The firm Calcutta Carpet Store continued as a tenant in respect of the said premises.
In fourth paragraph of the written statement, it is mentioned
The firm Calcutta Carpet Stores continued as a tenant in respect of said premises until the death of Ramchand in 1980. This should have been Gopal Das.
19.
Ramchand in 1980, which should have been Gopal Das.
It should have been Gopal Das.
Gopal Das.
So you have just deposed that Ramchand should be read as Gopal Das. Yes.
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 You have also please see question 3 and your answer, where you have said that you have gone through the plaint. What do you say about the contents of the plaint? I'm showing you a copy of the. I'm showing you the plaint. Please see and indicate what you have to say about the contents of the plaint.
When I was cross-examining the same question, one of the witnesses answered, yes, this contains the first paragraph, second is having the bond paper.
First page, second page. My juniors are saying that we are sitting here to control you. One. Mr. Ratul Das was also there. Come to watch the fun.
Basically, the plaint states that we've been tenants.
Correct or incorrect? Just say that.
Correct.
Now, what is that is correct or not?
No, it's incorrect.
Already বলেছি আগে তাই জন্য বললাম নাহলে বলতাম see question 11 he has said so. Have you heard of a partnership? I'm sorry, delete the question please. What do you know about Ramchand and Hashmat Rai? Hashmat Rai. Right. Which names you have taken in answer to question 12? And who were these persons?
Hashmat Rai and Ramchand were partners who formed the company Calcutta, who formed the partnership firm Calcutta Carpet Stores under the tenancy of the plaintiff. And they continued this business in 1957.
What business was this?
This business of selling hosiery.
1 second. We continued this business in 1957. Next, what business was this?
It was a hosiery business, basically selling hosiery items.
Hosiery business.
What happened in September 1957?
September 1957, Ramchand expired. And Gopal Das, his son, succeeded in his place.
What do you mean by succeeded in his place?
He was Gopal Das was his son. And
Repeat it. What do you mean by succeeded in his place? Can you explain your statement?
He came in as the new partner in the partnership firm.
What was the name of the partnership firm?
The partnership firm was still Calcutta Carpet Store.
Carpet store.
Where was business of Calcutta Carpet Stores carried out from?
Park Street, 43 Park Street.
And who were the tenants under the plaintiff?
The new tenants were...
who were the tenants under the plaintiff? Now answer the question.
Hashmat Rai and Gopal Das.
Shown Exhibit D. Oh, I'm sorry, no. Wait, D, E is done. E is done. F. No. Please see questions 17 and 18 and the answers thereto. You've said that the firm automatically stopped functioning after the death of Gopal Das. What happened to the hosiery business and the tenanted shop room of Calcutta Carpet Stores, the partnership firm?
Once Gopal Das expired in 1980.
1980.
The firm had stopped functioning basically as per operation of law, by law. And Mr. Hashmat Rai health was not permitting him, so he handed back possession to the plaintiff.
So he handed back possession to the plaintiff. When was this handing back possession to the plaintiff?
In the same year, 1980.
What is your next association? Nah, please delete. Was there any other business with which, now was or is there any other business with which you are associated run from the same premises?
After this thing,
Was or is there any other business with which you are associated run from the same premises?
yes, carpets business.
Yes, carpet business.
How did you run the carpet business from this premises? How did it start?
Around 1990, my elder brother Suresh Gyani and we entered this suit premises, which was shut. And my brother, who's no more there, he was responsible, along with me, to enter the suit premises. And since then, we've been using this premises as owners. And we've been carrying on this business of selling carpets from here.
When you entered into possession in 1990, what was the role of the plaintiff?
This was basically an abandoned property, and there was nobody there. And we started occupying it as owners.
What was the plaintiff's role or reaction to your occupying this property as owner?
There's never been any communication regarding anything from the plaintiff side ever.
Did the plaintiff know that you had entered into possession of the property?
Yes, sir.
How do you say so?
There are a few things that we did after we got into the premises. Firstly, we renovated the premises. Trade licenses were issued in our favor. From the departments, we did renovation work, and we got these permissions from the KMC department, from Borough 7 KMC department, which we were given. And also, we had given a newspaper advertisement stating the same.
Shown. Five and 3. Five, 6. Shown the originals of the documents at pages 85 and 80 of the documents. What are these documents?
These are the trade licenses, basically, that we received.
May I have leave for 1 minute? There's been a death, Millard. I'll just, somebody very close to the family, I'll just one phone call, I'll come back. No. Correct me. For a document.
I said trade license copy.
These are the trade license.
Who has issued it?
This is issued by the Calcutta Municipal Corporation.
The
And there's been never any objection also from anybody.
document may be exhibited.
From your side?
Yes.
Exhibit one collectively. There are two.
There are two collective.
One collectively.
So, just keep page number 87.
Exhibit করেছো এটা বলো with your lordship's leave. On page 87 of the judge's brief of documents, সবকটা একসঙ্গে দাও, কত সারা জীবন করে যাবে না হলে। 87 and 80.
88, 89.
Shown 87 to 89 of the judge's brief of documents. Please tell my lord what these documents are.
These are also the trade licenses that have been issued by the Kolkata Municipal Corporation.
How do you?
These are mandatory to basically start any form of business.
May I have them exhibit?
Not exhibit.
Yes, sir.
Exhibit.
Exhibit
two. One or two.
That was one collectively. You want to exhibit this also?
After this, I'll show page 91, 92.
No, this 89. 89 is, that was the 89.
18.
That was the earlier which has been exhibited, the same document. No, this is another document.
First document was, which I had shown.
Yes, original one.
Yes.
He has identified and exhibited that.
As the trade license comes out from the website. So there, that's why I asked the question, shown page. And only the last page is the original.
Okay.
So I'll keep that on record.
So you.
Because that is, I think, the money receipt. So that comes in. Dekho the last পাতাটা।
ওই দুটো দেখালো তার লাস্ট
পাতা original না? Last পাতাটা?
Payment receipt.
Payment receipt is always in original. So that we have.
तो अलग है ना? So this will exhibit 2. Exhibit 2.
এটা কত? ও অত মাথা ঘামিও না।
Yes, next.
Shown pages 91. Shown the originals of page 91 and 92 of judge's brief of document. Please tell my lord what this document is. I'm not asking five questions on one document. Actually, we have also now stopped doing that. Times have changed. Huh?
This is the order that we received for repair of our premises
From?
From the Kolkata Municipal Corporation, Buildings Department.
Exhibit 3.
When you had asked, when you asked for permission from the Kolkata Municipal Corporation to repair your property, was the plaintiff involved in the process?
No, we had sent a letter directly as owners to the KMC for repair.
Shown the original of page 93. What is this document? And who has received it? Look, this 10 questions I've seen when we joined. One document, 25 questions.
One matter I kept for
This is a letter to the Park Street
deliver
Police
judgment.
Station.
When I was preparing the judgment, I find the 2,500 some questions and answers.
One document. In 5 minutes, I'm showing you a document. I'm so allergic to it mentally and so vociferously allergic. I'm showing you a document. Comes the question, which is at page 4 of Judge's Brief of document, equivalent to page 3 of plaintiff's disclosure, equivalent to page 7 of defendant's disclosure. The times have changed.
Is the letter to the
Original I am producing. That's the end of the matter. Unless this nobody said it's a
disputed, yes.
This is a letter to the officer in charge, Park Street Police Station. It's a permission letter that we received from KMC to carry out repairs or work.
Did Park Street Police Station receive this
Yes,
letter?
yes, it's been received by the.
How do you know that?
There's a sign there, stamp and signature there.
Whose signature appears? I'm sorry, delete. Shown the
Exhibit 4.
Shown the originals of pages 94 to 97. You've got plenty of pages there. কটা দিয়েছো? না না ESI চালান
এর আগেরটা 91 92
হ্যাঁ
91
ও তাতেই বলো no you got up to 103
বললাম তো
103 on page 94 to 104 of the judge's brief, original of pages certain of judge's brief of documents. 3 হবে না 103 What are these documents? Tell me in a gist and quickly.
These are ESI documents basically. Challans or whatever payments have been made. Employee state insurance.
Why are you relying on these documents?
Because these are very important and we have got these registrations and we are directly from the ESI department.
What do you mean by, if you just delete this, shown pages of these.
Exhibit 5.
Exhibit 5.
Collectively, है ना?
কত?
5
collected.
একবারে one question. Doesn't matter.
Yeah. বলবে আমাকে হ্যাঁ ওখানে এমপ্লয়ি স্টেট
এটা এতগুলো পাতা নেই এখানে সব আছে তো which pages, originals of which pages? 108 to shown the originals of page 108 to 117 এগুলো অন্য of the judge's brief of documents. What are these documents?
These are documents pertaining to
Fiscal Code
employees'
Section
provident fund
128.
receipts of all payments made.
And all of this, your lordship may be pleased to drive out from the court. Only commission. Don't disturb me.
No, here only I find, but other courts.
Everywhere else.
In the Chennai and Madras High Court and all these things, I think Bombay also, the registrars, if it is come to the evidence,
Yes.
then the file will send to the registrars, they will record the evidence, then it will come for
And
argument.
when you come, don't come if you don't have your notes of argument
Correct.
ready.
Correct.
And when you bring your notes of argument, don't waste my time. I'll give you 1 hour. And then file notice there, 1 hour to explain note judgment, and then decree comes after 1 month or so.
There is nothing.
I have been, my lord, vociferously requesting that please do not take any evidence in court, send it all to registrar.
That is required, that amendment is required here.
No, amendment is to the original side rules.
Now the commercial rules,
No, commercial.
practice and procedure.
No, commercial courts act, there is no problem.
There is no problem, but with regard to evidence, see, commissioner is okay. Otherwise, why the court, the High Court will take the evidence? Let them go to the registrars.
Yes.
Go to the either
Absolutely.
commercial or the original side.
Or, my lord, if your lordships
Waste of
point
times of
learned judges, my lord, from the retired learned judges from the district judiciary, they'll be happy to, my lord, be appointed as commissioners and record evidence in the court premises. At least 5 such matters would go on. Each matter going on means, my lord, 10 juniors are involved. So, my lord, as a result, 50 juniors have suit work every day. You know, they are benefited, original side is benefited, there'll be more filings. And commission has to be in during court hours, not 4:30.
Not 4:30. Court
It has
hours.
to end at 4:30.
Because if the retired judge and all these things go and adduce your evidence, there is no necessity of the Saturday,
And
Sunday.
it also cannot be prohibitively expensive.
No.
Because if you make commission like an arbitration, people back off. A nominal fee for the learned commissioner, nominal fee, and court staff is there to take record evidence, and no extra charges for anything. Only
Yes.
then.
5K is given, 2 lakh rupees, okay. 1 month. Let you record the evidence.
That is the only way the original side will prosper. Think of the amount of time your lordship would have to deliver judgments in suits.
123, 123.
ওটা mark করিয়েছো?
No.
Exhibit
6. Collective.
No, shown page 122 to 120. 122 to 120. 120 to 120. 123. What are these of the judges brief? What are these documents?
These are also of employees' provident fund organizations, challans and payments that have been made.
All these originals of, Give it for it. This is shown page 124 and 125.
Exhibit 7.
124 and 125. What is this document? We are done, right? Yes. Exhibits. Oh, sorry.
These are also challans and payments that have been done to Employee State Insurance Corporation organization.
কোনটা? এটা বোধহয় করিনি। নেই তো, ছেড়ে দাও। all these documents being exhibit.
Exhibit 8. Collective. Collective.
All these documents being exhibits 1 to 8 concerning the business run from the suit premises after 1990. How did you get these documents?
We applied to the KMC department direct and to these various departments of Provident Fund and ESI directly, and we received the
Documents. Then, in 1990, now you have deposed that in 1990, you started a business. What was the name of this business?
90 we started Calcutta Carpet Stores.
What kind of a business was this?
This business was primarily dealing in carpets.
What was the constitution of the business Calcutta Carpet Stores?
It was a partnership concern.
Please have a look at the name of the defendant in this suit. What is the constitution of the defendant?
Calcutta Carpets Private Limited.
Is there any connection between Calcutta Carpet? Sorry, wrong question. Where did Calcutta Carpet Store, the partnership firm, carry on business from?
From the same premises, Park Street.
Till when did it carry on business?
Till 91.
What happened in 1991?
In 91, the firm was dissolved and a new firm was started by the name of Calcutta Carpets Private Limited.
By the name of
Calcutta.
Which is a defendant.
which is
And this was a takeover of the existing business.
The defendant a partnership firm?
No, it's a private limited company.
2 questions back, you mentioned in answer to the question before the previous question, you said that in Calcutta Carpets Private Limited is a firm. You want to correct yourself?
Answer to follow.
What was the question?
Previous question.
Is it a firm? Then he said it's a company.
Calcutta Carpets.
Calcutta Carpet Store, partnership firm, carry on business from the same premises. Till when did it carry on? In 1991. What happened in 1991? In 1991, the farm was dissolved and a new farm was started by the name of Calcutta Carpet Private Limited, which is the defendant. And this was the takeover of the existing business. What was the constitution of the business Calcutta Carpet Store? It was a partnership firm. Now,
Calcutta Carpet Stores was a partnership.
Store was the partnership firm. He is telling that the Calcutta Carpet Store was a partnership firm.
Yes.
He has stated that.
In the last question was in the
question before the previous question.
In the question before the previous question, you have mentioned that Calcutta Carpets Private Limited is a firm.
No, he has not stated.
last question. It
Private limited is a
Questions
firm, he has stated? No, I don't think so.
Then he said it's a company.
1991, the firm was dissolved.
Yes. Then
A new firm was started
yes,
by the name Calcutta Carpet Private Limited.
this is the
Okay. That was an error.
that was an error. এটা কোন document?
Yes, how many questions now?
Milord, maybe 5. কোথায় এটা? Milord, really 2 questions and 1 document which I want to disclose. Next day, Milord, for his cross-examination, 1 or 2 questions in chief.
Yes, record.
He'll anyway have to come. I'll just disclose that one. That articles of association. Right?
Dependent witness.
Oh,
No? Dependent witness is present. Examination chief resumed. During his examination, documents were marked as exhibit 1 to 8. 8. Full stop. Due to paucity of time, examination chief could not be completed. Accordingly, chief is deferred. Let the matter appear on December 1 at 3:45 p.m.
Well, could it be any time before that?
Huh?
Could it be any time before that? Well, it's my prayer.
কালকে থেকে হয়ে যাবে?
Yeah, that also we're agreeable. We have no difficulty at all. But since he's already been examined,
Chaudhary also,
yes, no
my
difficulty. at
learned
all.
friend senior shares the same views. We have to have a mindset change. And Lord, please force all of them.
Well,
Now, the rule committee, you all persons is to be included so that
No. If your lordship forces them now, anybody who comes and asks for a date for commission, for examination, no, I will not allow. Go to commission.
no. Yeah, let the matter appear on 1st December 3:45 for further examination chief and cross exam. Yes.
Being for 10-minute accommodation, Mr. Shivshankar Banerjee on legs in court number 3. This matter is running.
10 minutes,
10 minutes.
makes it very.
Time will be over. Yes, already completed. What remains?
Only one judgment perhaps he want to show your lordship, and that's why.
What will do 10 minutes?
But at the same time, my lord, I could have started today after he finished. But I don't want to start and then be interrupted for 10 minutes. In that case, my lord, instead of 10 minutes may run into 15 or 20. This side of the, my lord, kindly fix a date there. And he was supposed to give us a copy of the judgment that also has not been given.
What is the judgment?
Corbonash. He's walked out.
Well, I'm not placing the judgment with your lordships. Since Mr. Banerjee wished to hand over this judgment to you, better he appear and make submission.
You give the citation to them so that on next day they will come ready.
Definitely. Before that, I will.
Though the matter is specially fixed today for argument at 3:45 p.m., but the learned counsel for the defendant is busy in the other court and accordingly.
Kindly record, my lord, that they were not here to present the case because it's had a very checkered history.
Wait for time. For the interest of justice, the case is adjourned. Police to the learned your advocate on record? No.
Yes.
The learned advocate on record submit that the plaintiff only intend to the learned advocate appear the arguing counsel on behalf of the plaintiff intend to place one judgment. In view of the above, the plaintiff is directed to the defendant is directed to give the citation in advance to the learned counsel appearing for the plaintiff so that on the next date fixed hearing argument can be completed. Is the matter on?
Well, let it be understood if they are not there the next day, I will start.
Is the matter on? 11th November at 12:30 for argument. It is made clear that on the date fixed, if the defendant failed to argue the matter, the argument on the side of the defendant will be closed and the plaintiff will be allowed to commence the argument. Yes, next.
Number 18.
Your Lordship, I am appearing on behalf of the plaintiff.
Yes.
Item number 18, my lord. I appear on behalf of the defendants. My application under Chapter 13, my lord, for dismissal.
Chapter
13, my lord. 13.
Yes.
Under the Commercial Codes Act, the dismissal of suit. My lord had granted them to file an affidavit. My lord granted them a period of 4 weeks. They came and sought for extension on the 5th week. My lord had granted a further 2 weeks period. On that also, they are belated by another week.
Your Lordship, the authorized signatory of the plaintiff was the mother of the authorized signatory of the plaintiff was hospitalized. As such, it could not be filed, could not be affirmed within time. Your Lordship, after that, 3 days holidays was there, 5th of September, and after that, Saturday, Sunday was there, and on the next working day, the same the affidavit in opposition has been served to the opposite side, and since it could not be affirmed, all I am praying for extending the time. It is ready in my hand, Your Lordship. Advance copy has been served to the opposite side.
I have received, my lord. I have received. I must say, I cannot say that I have not received.
So you will not file reply.
My lord, there is one submission that is made in the affidavit which is beyond the plaint. I will have to give a response to that. But kindly give me a very short period for me to file my affidavit and reply and fix it any day.
Plaintiff has filed affidavit in opposition in connection with GA5 2025. After serving the copy to the learned counsel for the defendant, let the same be cut with the record. Counsel for the defendant prays for time to file affidavit in reply. Let affidavit in reply be filed within a week after Puja vacation. Please the matter.
May I?
18th November.
May I request this? I know Milord's diary for fixing a matter in November is full. If it so commences to my lord, fix it on any day at a specific time, we shall come in here.
January 2026.
Their suit, my lord, we don't have an objection. I am the defendant, my lord. Their suit, I don't have an objection.
What date?
November, nay, George have a nay November. My lord, put any time kindly, my lord. We shall complete it.
We date hai January.
My lord, keep it January 2027. I don't mind. Then we'll try our luck in November. Extremely obliged.
Number 20.
This is the matter.
Item number 19, my lord.
This is in item number 19. I'm appearing. I back to appear through virtual mode, my lord. I'm appearing for the defendant. My GA number 4 is listed before this honorable court, my lord. This is seeking a return of plaint on the ground that there is no territorial jurisdiction of this honorable court.
Lord, I am for
the
the
goods were supplied at the Raniganj, the manufacturing.
Lord, may I?
They have no
Lord,
cause
I'm
of
for the
action in the-
plaintiff, my lord.
So sorry.
My lord, they have filed an application, my lord, that my learned friend is moving, my lord. There's my application also, my lord, GA1, in which your lordship had directed them
Yes,
to
my
file
lord.
an opposition, my lord. My lord, on Thursday, my lord, on the 18th, your lordship had extended the interim order up to the 13th of November. Your lordship may fix the matter on the 13th, my lord. In the meanwhile, the
Morning, Mr. Shah has mentioned the matter. Date is fixed already.
Very well, my lord. We'll come back on that date.
In the meanwhile, my lord, I make a small request, my lord. This is a matter of small recovery of rupees 10 lakhs. My lord, my client is willing to settle with them and he wants a hearing before the mediation. if that is possible, my lord.
For 10 lakhs, you want to go to a mediation?
No, it's not about 10 lakhs. We just want to settle this matter. It's
Settle
not
it.
about 10 lakh or.
Come.
So,
You decide what
my
Yes, my lord. They can
meantime-
directly offer us, my lord.
on 25th, what you
no,
are
it would be better if my lord may refer the parties to mediation, because my client is willing to travel to Kolkata and he wants to settle it out.
My lord, in that case, may
That's what I'm telling. Please tell your client what is your how much amount you are ready to pay. Communicate to the plaintiff. If the plaintiff is ready, then I will send the matter to the mediation. The settlement agreement will be executed. No problem.
Very well, my lord. There is another concern.
24th already the fixed matter at 11:30. 25th.
September.
25th at 11:30 matter.
25th of September, my lord.
September.
If my lord may fix it after vacation, my lord, the pleadings may be
Morning कौन mention
My lord, perhaps it was without notice. My lord,
No notice of mentioning was served upon us, your lord.
You are appearing for whom?
I'm for the plaintiff.
I appear for the
Mr.
defendant.
Jishnu Shah appearing for whom?
My lord, Mr. Jishnu Shah is not in the matter.
Mitro.
This is some other matter, perhaps. My lord.
Somebody has mentioned, Mr. Mitra has mentioned.
No, my lord. We have not instructed anyone on behalf of defendants. Advocate on record, Mr. Dipender is there. We have not instructed for any mentioning, my lord.
नहीं हम तो मार्क नहीं किया कहाँ से मार्क
My lord, it was not mentioned, my lord.
Perhaps this matter was
Yes.
not mentioned, your lordship.
My lord, perhaps there's some misunderstanding. There was some other matter.
वो कौन सा था जिसु शाह है वहाँ पे तो Mr. Shah, you mentioned the matter morning. Which matter you mentioned? There was some confusion because 19 you mentioned.
No, 90.
90.
Oh, sorry. My lord, can I also draw your attention to one issue before this court, that this is a commercial suit. I have never been served with the plaintiff. We have been directly served with the summon without any annexure of the GA number 1. So, my lord, if my lord may consider giving me liberty to file written statement to the main suit, I can also be filing that also within 4 weeks, my lord.
Yes, affidavit filed.
Yes, my lord. On the last occasion, my lord, I had directed my learned friend to file an affidavit, my lord.
Affidavit in opposition by 2 weeks. Reply if any.
Yes, my lord, that has not been filed, my lord. In the meanwhile, they have come up with an application, my lord, for revocation of clause 12 leave, my lord, which my learned friend was moving, my lord. We'll file an opposition to that, my lord. On Thursday, my lord had extended the interim order up till 13th of November. Your lordship may fix the matter on that day, my lord.
Okay, come on, 13th November.
In the meanwhile, my lord,
it is submitted by the learned counsel for the plaintiff that by an order dated
my lord, 18th September.
18th September 2025. This court has extended the interim order and fixed the matter on 13th of November 2025. Let the matter appear on 13th November.
In the meanwhile, my lord, the pleadings may become.
In the meantime, your lordship, we'll file our affidavit in opposition.
I'll file whatever it is.
GA1.
In the meantime, the parties are at liberty to complete the pleadings. Yes.
Grateful.
I'm sorry to disturb you.
I'm much.
Fine matter. But if it could be made matter or at least a recording that it has been heard by your lordship on many occasions.
It is argument. It will become what? Don't worry on that.
In case there is a change, my lord. That is why.
तो पाठट कर दो इससे पहले वाला था ना कौन लिया
No, I've brought the other side.
नहीं वो नहीं
Item A, 3:45 PM is it?
Yes, next. अरे ये नहीं हो
20, my lord.
पाठट कर argument वाला
In 20, my lord, this was my application that was being heard. That's a Section 8 application.
I was addressing, my lord.
My learned senior friend.
Remember exactly what I had shown last. But this one, but so far, but I'm not going. This is a section
This is an application for rejection of plaint.
Not a section.
The argument has been on purely Section 8. Kindly see the application, the master's summons. The master's summons, Lordship may.
Master summons का है? इसका पता नहीं देखो. Yes, I remember.
I think Lordship sees kindly the application is for rejection of plaint.
Not for referring.
Not for reference to arbitration. And I was submitting, well, my submission last day was there has to be an application because this is not a case of inherent lack of jurisdiction of the court. Because Section 8 makes it optional for the defendant to come to court.
Correct.
So unless there is an application, there are judgments to that effect. Unless there is an application, the court will not
refer.
And
It cannot be said that it is not maintained.
Application has to be made within a certain time. Then there's a certified copy annexed. There may be curable, some of them. Certified copy of the agreement annexed. The court may give leave to correct.
You relied upon the Hyderabad bench.
Yes, well, I had relied upon the Hyderabad judgment, division bench of Hyderabad High Court, and also I think I really don't remember exactly what
of this court.
Yes. Then the Bhanumati's judgment, I do not remember, Lordship shouldn't be asking my lord the question whether did I place this Golia Katwala Bhanu?
No, I am telling you have cited the Andhra Pradesh judgment, Sankara Reddy.
Yes.
Then of our division bench, Seri Equipment.
That is 2012 or 2017, Lordship?
2017.
17.
Seri Equipment. Then 2011, SSK Construction.
2011, that is 12 to CHN, yes.
Yes, 12 to CHN. Yes, these are the documents. These are the and
I'm so grateful to Mother. I can because my junior who was there assisting me now he has just now appeared in the scene. So to me,
these are the three judgments you said.
Hanumati.
No, four judge. Three judge.
Now I will place my lord. This also Andhra Pradesh High Court. This is Bhanumati's judgment as a leadership then was Golia Katwala. Golia Katwala. No, 2001 one arbitration law report now. Good. Golia Katwala. तुम्हारा iPad दो तुम्हारा iPad को और iPad नहीं खोल अभी तक तुम्हारा एड्रॉप कोई नहीं पता Lordship is take advantage of my lord being tech savvy. What will you? What two questions are tomorrow? May I hand up my lord? The tomato show goods. No, okay. Lordship, this judgment, Lordship kindly comes to আমি তো এড্রপ করেছি তাও তো তোমার তোমার আছে তোমার আই জাস্ট গিভ ইট টু দেম আচ্ছা পাওয়া গেছে তো হ্যাঁ দিয়ে দাও ঠিক আছে দিয়ে দিচ্ছি কপি may I come straight away to paragraph 9. There is a reference to an earlier judgment, which, if I may please. Paragraph 9, he further submitted that since the ground required to seek the relief under Section 8 was taken in the written statement itself, mere filing of the present petition sometime thereafter does not vitiate the requirement of compliance of Section 8 of the Act. And therefore, it must be treated as sufficient compliance of the provisions of Section 8. He placed NCC Limited versus State of Andhra Pradesh, wherein at para 32 it was held as follows. It may be noted that Section 8.1 stipulates in no uncertain terms that a party who seeks to raise an objection thereunder to an action brought before a judicial authority must apply no later than when submitting his statement on the substance of the dispute. In the present case, the second defendant filed his written statement in 2015, but long prior thereto it filed the subject IA Order 7 Rule 11D, in which it raised amongst grounds of applicability of Section 8. The trial court, however, was of the opinion that as the defendants had not filed a separate application on Section 8, they could not be permitted to raise such an objection under Order 7 Rule 11D. This pedantic approach was not warranted in light of the light in which Section 8.1 of the Act is couched. It is sufficient to, if the aggrieved party applies to judicial authority, be it whatever form under Section 8.1, but before submitting the first statement under the substance of the dispute, filing of a separate application, therefore is not mandatory. The court considered this judgment. Thereafter, Lordship kindly comes straight away now to paragraph 16. Of course, there is no format prescribed for filing an application under Section 8 of the Act. However, in one form or the other, the relief available under Section 8 should be claimed by the defendant not later than when submitting his first statement on the substance of the dispute. Therefore, if the defendant does not seek to refer the parties to arbitration, the court does not on its own refer the matter. According to the petitioner, since the existence of arbitration clause is mentioned in the statement and that the civil court has no jurisdiction, it cannot be treated as an application by the defendant seeking reference of the parties to arbitration. It does not reflect the intention of the defendants to seek the court to refer to arbitration. What all can be culled out from any such statement in the statement is that the defendants are denying the jurisdiction of civil court. As already noted, mere existence of the arbitration clause does not take away the jurisdiction of the civil court. As can be inferred from the language of Section 8.1 of the Act, it is not possible to appreciate the arguments advanced in this regard. If the intention of legislature is to completely take away the jurisdiction of a civil court and mere existence of an arbitration clause in the contract for reference to dispute to an arbitrator, legislation might have used different language by which the right is conferred on the defendant to challenge the civil court's jurisdiction at any time. In the decision in NCC, the one which is mentioned earlier, cited by the petitioner, under Order 7 Rule 11D, like the one in the present case, was filed, but argued to grant the relief under Section 8.1 of the Act. But the fact remains that such an application was filed within the time stipulated under Section 8.1 of the Act, whereas in the present application, written statement was filed in March 13th and the petition was filed in year 17, and therefore the said decision cannot help the petitioner to support the application of in the present case. Because even if the petitioner filed in the year 2017 under Order 7 Rule 11D is treated to be one under Section 8, the same is filed far beyond the filing of written statement. In that itself is a ground so and so. In that case, pleadings in written statement are not treated as enough
form to apply for reference under Section 8 of the Act, either in the written statement or in the petition in the present case. The relief claimed is not for reference of the parties to arbitration and is only to reject the plaint, to put an end to dispute before the civil court. There is no dispute about settled proposition of law. An application in Order 7, Rule 11D can be disposed of, basing only on the averments in the plaint and the documents annexed thereto, but not the defense raised in the written statement or the document filed by the plaintiff. Thus, there is no merit in the contention of the revision petitioners, even for examining the contention of maintainability of the suit on the ground of existence of an arbitration clause, since an issue in this regard was framed, which tried to be the mixed question of law. 21 একবার দেখিনি দেখি I'll give you 1 minute, Miller. Lordship, may I hand up, my lord, 2001, Volume 1, Arbitration Law, page 205. Paragraph 8.
Paragraph
8. Paragraph 7, my lord, paragraph 7 and 8. 7, page 209, section 8 is quoted. After the quotation, this is the last page of the subsection 1 of section 8 specifically speaks about applying to the judicial authority for referring the parties to arbitration. Subsection 2 of section 8 stipulates that the application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. In view of the clear provisions in section 8 of that, it cannot be held that for the purpose of section 8.1 of that, a formal application is not required. It cannot be held there. Considering the whole scheme of the Act, the option available to the party to subject himself to the jurisdiction of the judicial authority without resorting to arbitration, the stipulation of time when the application for reference should be filed, and the specific condition that the application should be accompanied by the original arbitration agreement or a duly certified copy thereof, I have no hesitation to reject the argument that the application section 8 for referring to arbitration need not be a formal application. Need not be a formal application. Admittedly, the formal application of the appellants was filed later than when submitting their first statement, substance so and so. Therefore, application was beyond time. Now, paragraph 8. It is also necessary to observe that there is no merit in the contention of the counsel for the appellant that there was substantial compliance with section 8.1. It is true that the appellants in their reply to the company petition had referred to the arbitration clause contained in the agreement and had questioned the jurisdiction of the company law board to entertain the company petition. But even in the said reply, the appellants did not specifically pray or request that the parties be referred to arbitration. This omission on the part of the appellants has to be viewed in the light of the fact that a party can question the jurisdiction of the judicial authority and plead for dismissing the company petition on the ground of lack of jurisdiction without praying for referring the parties to arbitration. The pleadings contained in the reply to the company petition indicated that the appellants were pleading for the dismissal of the company petition on the ground that company law board had no jurisdiction in the matter in view of the arbitration clause. They were not praying for referring the parties to arbitration. Therefore, it cannot be accepted that the mere averments. And here, my lord, I will beseech my lord to come to the application. They are relying upon a forum selection clause. They have relied upon a forum selection also. Kindly see the affidavit in support of master's summons, page 6. Page 6.
Yes.
the last paragraph. In the present case, it is obligatory for the Honorable Court to refer the parties to arbitration in terms of their arbitration agreement, and nothing remains to be decided in the original action after such an application is made, except to refer the dispute to arbitration. By virtue of the loan agreement, the parties have also agreed that the courts at New Delhi have exclusive jurisdiction to adjudicate upon disputes arising out of the said facility agreement, as per clause 22. The plaintiff has also addressed numerous correspondence, including the last demand letter, the 3rd May 24, to the defendant's said New Delhi office. As such, part of the purported cause of action of the plaintiff has arisen within the territorial jurisdiction of courts in New Delhi. As such, the forum selection clause in the loan agreement confers exclusive jurisdiction on the courts in New Delhi, and this Honorable Court lacks territorial jurisdiction. So it is not that this is the only objection they have. Their objection is that the court does not have jurisdiction. What you can see is page 4. Page 4, what is their case? Their case is section 5, the court doesn't have jurisdiction to hear the matter. So their case is lack of jurisdiction. That is, otherwise one can file in and make an interlocutory application there. They refer to arbitration clause and say, I have. But court, for losing its jurisdiction, of course, it is mandatory. Once the court finds that the arbitration clause is there, the conditions of Section 8 are fulfilled, and the suit is covered by the arbitration agreement. But court suo motu doesn't have the jurisdiction to do it. So this was my now I go to the parent judgment, which has, though not been followed in so many, though I feel that this is very relevant on this question whether application is necessary. This is a well-known judgment in P. Anand Gajapati Raju's case. Page 542.
Yes.
Paragraph 5 of the judgment. The conditions which are required to be satisfied under 8(1) and 2 of the before the court can exercise its powers are: there is an arbitration agreement. A party to the agreement brings an action in the court against the other party. Subject matter of the action is the same as the subject matter of the arbitration agreement. The other party moves the court for referring the parties to arbitration before it submits its first statement under the substance of dispute. The last provision creates a right in the person bringing the action to have the dispute adjudicated by the court once the other party has submitted its statement of defense. But if the party who wants the matter to be referred to arbitration applies to the court after submission of his statement, and the party who has brought the action does not object, as is the case before us, there is no bar in the court referring. So there has to be an application. That's what my humble submission is. Because otherwise the court has jurisdiction, and in case now they filed the written statement. So if they file a written statement as they filed here, their rights, or they don't annex the certified copy of the agreement, then their right goes. Agreement copy agreement copy.
You filed the WS?
They have filed. Yes. But of course, there's a point taken that the court does not have jurisdiction. Section 5. I will read out their from their written statement. Yes, there is a binding clause 22A. The arbitration clause requires all parties to be referred to arbitration. The subject matter of the suit is covered by the arbitration clause, and the plaint ought to be rejected. The purported subject matter of the present suit ought to be referred to arbitration. It is further submitted that in terms of Section 5 of the 96 Act, no judicial authority shall intervene once it comes to the conclusion that there is an arbitration clause. Thus, once the judicial authority finds that there is an arbitration clause on the subject matter of the case and refers the parties to arbitration, then on account of Section 5, judicial authority will lose jurisdiction. So but they have to apply. They have to apply. That application, they may do it tomorrow. They may do it tomorrow, but then till that application is there, this cannot be. Now, Malad, I was 4-2 arbitration operation. 4-2 আর 8-2 Lloyd's law report আছে এটা কোন জায়গায় এটা নোট করা নেই Yes, Lordship kindly takes a look at that 2004 Volume 2 Arbitration Law Report 6-1. So kindly comes to the last page. The present application is the oral prayer. Oral prayer for, like in our present case, their application is for rejection of claim. There's an oral prayer for referring the parties to arbitration. Kindly comes to the last page.
Yes.
In bold is Magma leasing case. Just after that bold Magma leasing was the NEPC, on the next line. In my view, once the plaintiff opts to file a suit, it is no longer open to him to pray to the court that the parties be referred to arbitration. The present case is not one where the plaintiff can be heard to plead ignorance of the existence of. Furthermore, counsel for the plaintiff made an oral request that such a referral should be made, should take place, but this submission does not fall within the purview of Section 8, which specifically envisages that a request of this nature should be contained in a written application. So here there is a written application for rejection of claims and an oral application for reference to arbitration. And the same that just because the court is informed of the arbitration clause, next sentence, I am fortified in this view by the pronouncement in Garden Finance. It has been contended by the counsel for defendant number 2 that this court is duty-bound to refer the parties to arbitration. No sooner it is made aware of the existence of the arbitration clause. I cannot accede to this argument in view of the Sukanya holding. They have also said here, I am making you aware that there is an arbitration clause. But that is not sufficient to make you. I can make you aware when I'm moving the first day when I move my suit, I have an arbitration clause. But I'm taking a chance here if the defendant does not apply. Lordship cannot say no, I will not entertain the suit. Yes. The next topic I shall move on to is the forum selection clause. Next I shall move on to is the forum selection. Well, one last judgment here and then I'll... I am not multiplying judgments, that the court does not have any lack of jurisdiction because there is the arbitration clause. The court knowingly can entertain a suit, can pass orders, but once the application is made, not an oral application. Now I move on to the next aspect, that is the forum selection clause. On the forum selection clause, that is clause that is clause
22.
22. Lordship kindly comes to not clause 22, that the forum selection clause is at page 32. Lordship kindly comes to the forum selection clause. The agreement starts at page.
Yes, exclusive. Clause 19 and 20.
19 and 20 exclusive.
Place of arbitration exclusive.
And Lordship, see the next clause also, clause 21. Place of execution, Kolkata. Now, Lordship kindly comes to paragraph. এখানে প্লেন লাগিয়েছো লাগানো আছে প্লেন না ব্রেক লাগানো আছে এখানে paragraph 51 of the plaint, running page 58. Running page 58.
Yes.
Paragraphs 50 and 51. After all, today we are at the demurrer stage. 50, the defendant is carrying on business from its office at... The defendant is carrying on business from 2/1 Russell Street, so within jurisdiction. Paragraph 51. The loan agreement admittedly has been executed in Kolkata at the defendant's, the then registered, the then Bangur BFLS, so and so. The loan agreement was, the loan amount was disbursed from the defendant's aforesaid office within the jurisdiction of this Honorable Court. The repayment of loan has also taken place in Kolkata from the plaintiff's said office, which is situated within the jurisdiction of the Honorable Court, and has been received by the defendant at his aforesaid office within the jurisdiction of the Honorable Court. The present office of the defendant also situated within the jurisdiction of the Honorable Court. In view thereof, the plaintiff's cause of action for filing the suit has arisen within the jurisdiction of the Honorable Court. Therefore, even though in terms of the loan agreement, the courts of New Delhi will have the jurisdiction to entertain the disputes arising relating to any matter or issue under or pursuant to the loan transaction, inasmuch as no part of the plaintiff's cause of action has arisen in New Delhi, such forum selection clause is of no consequence, and the same is the same has no applicability in the present case. So this is the averment on the basis of which I have filed the present application. Now, Lordship kindly comes to the application, page 6. While they have referred to how they have to say what part has arisen within Delhi. Lordship kindly comes to last paragraph of page 6. In the present case, obligatory for the Honorable Court to refer the parties to arbitration. So the fourth line of the last paragraph, page 6. By virtue of the loan agreement dated 28th of February 18, the parties have also agreed that the courts at New Delhi shall have exclusive jurisdiction to adjudicate upon disputes arising out of the facility as per clause 22. The plaintiff has also addressed numerous correspondence, including last demand letter of 3rd May to the defendant said New Delhi office. As such, part of the purported cause of action of the plaintiff has arisen.
Reported cause of action
has
within
jurisdiction. As such, the forum selection clause. Now, firstly, I have to go by on the demurrer principle. And secondly, if at all one has to make out a very high case that you look beyond the plaint, they have to show two things. They have to show how the court has jurisdiction. And secondly, a mere demand does not give the court jurisdiction. If I give a demand in
Delhi,
and Delhi doesn't mean the court has jurisdiction. The cause of action is where the right to sue arises, where the agreement is entered into, or whether the defendant resides or carries on business. Just because one notice is given or two notices are given, the court will not have jurisdiction. Then I can choose any court in India just by giving notice. So mere giving of notice is not sufficient. Lordship, may I start? Or Lordship, maybe the next day I will start on the jurisdiction for a few judgments on this aspect. On the forum selection. If I was wondering if it's possible, my lord, Lordship is on Friday, we'll be all very light. In case my lord will have to sit anyway. So my lord, in case Lordship takes on Friday, then we can both of us can finish the matter on Friday. If it commends to my lord, then
whichever team will
against the tradition of the bar.
Against the tradition of the bar. My junior is not there.
Tradition of the bar.
Yes, it's true. But I want to finish the matter. Because Lordship has heard the matter. I don't want to keep it in case the bench changes. I wouldn't like that. So that's the whole problem. And tomorrow day after, I just may get stuck. That's the whole difficulty. Or Lordship may remain in the list in case I will try my best.
Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter remain in the list.
Item
Yes.
number.
My lord, one. I'm sorry. No, কিছু দেখুন. My lord, one leave I'll require. My lord, we've already filed a written statement. My lord, the affidavit under order 11, which is to be part of the written statement, my lord, that's not inadvertently. In this matter itself, my lord, in this matter, we have already filed written statement pursuant to leave of my lord. Only the order 11, my lord, affidavit has not been.
Document filed
Yes,
by
my lord.
the defendant be kept in the record.
Deeply obliged, my lord.
Yes.
Well, item number 24, my lord, is that money pyramid matter which your lordship disposed of. My lord, there's a question about appropriation of payments. They're not, my lord, appropriating the payments, my lord, against, my lord, the installments, against the, my lord, entire outstanding. My lord, that is why the application had to be taken out. My lord, there's naturally some.
What has happened to appeal?
Well, appeal, my lord, has not yet been taken up for here.
I had a my lord, on the first occasion last Monday it was taken up. It was adjourned at the instance of the plaintiff. I don't stand with you. They've also obtained an order extending the interim order. My lord. But I don't know if my learned friend has served or okay. ठीक है, ठीक है. I don't have any instructions.
Your lordship can, my lord, accommodate us tomorrow or even day after.
We just want to
Well,
deposit money. Kindly.
we want to deposit money in court.
My lord, today my
No,
seniors
appeal
aren't
is
here.
pending. Appeal is pending.
No, my lord,
No
appeal is, my lord, on a different matter. My lord, here your lordship has decided on the question of, my lord, the installment payments. My lord, now we are tendering money. They are not accepting it. My lord, they are wanting to appropriate against the, my lord, due of 102 crores.
There.
My lord, that is why we had to approach.
What has happened to the IBC?
Well, IBC, my lord, has not yet come up for hearing.
No,
तीन dismiss हो गया
for
defective.
Three applications dismissed for defect.
Oh, three applications dismissed for defect. And my lord, others, my lord, not yet
Subject to
matured for
correction,
hearing.
my lord, the IBC proceeding, it was appearing before the NCLT. This I'm saying on instruction, my lord, my advocate record was there. A submission was categorically made that my learned, because of the order passed by my lord, let the matter be adjourned. And it has been adjourned. Yes, my lord, this submission I am stating.
Last time, that's why he clarified.
Clarified in the order.
That's why he clarified. Because I know because this will happen.
I know that
No such
this
submission.
is the submission that I have been instructed.
Okay, whatever it
I am not on that.
Okay,
It's a very short matter. It's
let it be remembered. Today we
let
have
it
reached
remain
21.
Yes.
Let it be in the list.
Fair.
Let it be in the list.
Kind of to mention that item number 26, Milad innocuous prayer. Milad, let a copy of the plaint and Milad the petition be served on me. Milad, my advocate on record had requested the plaintiff's advocate on record, but I think that has been refused.
Why payment is not being made?
Milad, I have told my learned friend, Milad, I will look into that. Until unless I am been served with a copy, Milad, how do I revert back?
So the application can be served.
Let a order be passed, Milad, he will also be in difficulty otherwise. 26.
GA number 1.
One.
Counsel for the defendant prays for a direction upon the plaintiff for service of copy of the application being GA-Com 1 of 2025 and along with the documents. The plaintiff is directed to serve the copy of the application along with the documents to the defendant within a week from date. Advocate on record of the defendant. That is, within a week from date.
Till Friday, Milad. Week is not left.
Okay. By 26 September 2025.
Let it be after vacation.
List the matter on 6th November.
6th. Milad, 6th I am not there, Milad. A week thereafter. Milad, after 8th, Milad.
11th November.
11 November.
Also to judge. My lord, item 21, my lord.
Item
21. I appear for the plaintiff.
I'm
Suit
appearing
for
for the
recovery
number
of
3, my
money.
lord.
Now the defendant number 3 has taken out an application.
They
for
have paid the amount.
Not, my lord. If they had paid, my lord, no, my lord, I would be the
That's why
happiest person. My clients would
So
be
what
the
do you
happiest.
want?
Now they have filed an application for rejection of my plaint, my lord. I will file an opposition. They have also filed one application for acceptance of their written statement. So first, the Order 7, Rule 11 has to be dealt with, and thereafter the scope of.
You want direction for affidavit?
Yes.
Item number?
21. In fact, there are 3 applications. One
Who has
is
filed the 3 applications?
2 applications by them. Defendant number 3. One is under Order 7, Rule 1. Another is Order 8, Rule 1. Another is by the defendant number 2 for acceptance of the written statement.
The plaintiff prays for time to file affidavit in opposition in connection with all interrogatory applications
of the defendants.
Interrogatory applications filed by the defendants.
Number 2 and 3.
Let affidavit in opposition be filed within 2 weeks after puja vacation. A reply, if any, there to be filed within a week thereafter. List the matter on 26th of November 2020.
Great.
Ah.
And for the plaintiff, on the last occasion, my lord has asked me to serve on summons on the other side, and that has been done 2 times. It has come back with no block intimation sir.
Ah.
My lord, it's deemed service, my lord.
Ah.
My lord.
My lord,
So what do you want? Let it be discussed.
My lord, one more thing. One more thing, my lord. A short leave is required to draw up and complete an order of my lord.
Which one?
This is a order, old order of July 2024. Now clients
after 1.5 years.
1 year, urgent Xerox certified copy was obtained, but the requisition to draw up and complete was not given. Leave is required, my lord, to get those.
After 1 year, what appeal you will file?
See, my lord, client will understand, my lord. My duty is to obtain the leave and give it.